action.
You're in charge, Stephen.
Good morning, everyone. Welcome to the February 14th, our Valentine's Day edition of the Board of Zoning Adjustment. Before we start the official part of the meeting, I'd like to recognize Sarah Baxter, who's leaving us today to do other responsibilities within the city. She's been our lead attorney and been here for very, very many years and always so knowledgeable about the code and the committees and other parts of our organization. Sarah's leaving to do, as I said, to do other things in the city, but we do have Elward Allegri, who's going to take over in her position. So to Sarah, thank you so much for all you've done over these many, many years. Thank you. Thank you.
Thank you so much too, Chairman Evans. I appreciate it. And I've really enjoyed working with BZA
Thank
over
you,
the years.
Sarah.
Thank you.
We've enjoyed having you, as I said. And also, before we start, I'd like to thank all city staff who have assisted us in preparing cases that we will hear today. To people in the audience, they work tirelessly preparing for your case individually so that we have all the information we need to make judgments in your case. So thank you to all city staff. And to our volunteers around the table, we're in an unpaid position, but we're glad to do it for the city of Kansas City, Missouri. So thank you to my fellow board members. All right. Before we start to review the cases, I'd like to swear in all city staff members who are presenting or presenting testimony today. If you're online, please turn on your camera and microphone. And for those in person and online, please raise your right hand to be sworn.
Daddy.
Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today? Anna, please call the roll.
Daddy.
I do.
Jared.
Jared Clements, I do.
Anna Naniski. I do.
Anyone in the audience?
That's it. Just the
Okay,
three of us
thank you.
today.
And do we have our other two board members? Yes, I see them there. So thank you. So Anna, would you please inform us of the dismissals and or continuances so we can react to those?
Yep. And first, I'm going to talk about the procedures of the hybrid meeting, just for anyone who's new with us today. So we've got two categories: people online on Zoom and people in the chambers. For those online, there are two categories of participants. We have attendees and panelists. If you are a panelist, that means you are a board member or a city staff person. If you are an applicant or a citizen wishing to provide public testimony on a particular case, you're going to use the raise hand function when the chair calls that particular case. That's going to allow city staff to promote you on Zoom. There's a ribbon at the bottom of your Zoom screen that has a little hand. That's the button that you're going to click. When this promotion appears, it's going to seem like you've been kicked out of the meeting, but please don't panic. You will reconnect shortly. This is just you rejoining the meeting as a panelist. When you are a panelist, you'll be able to turn on your microphone and turn on your camera. This is very important as the chairperson swears you in, so then you can provide public testimony. Please change your screen name to your full legal name. This is going to help city staff with that promotion that I just mentioned. And if you are on the phone, if you're wishing to provide public testimony, you can use the *9 key, the *9, and this is going to inform city staff that you wish to be promoted if you are on the phone. If you are in the city council chambers, you're going to approach the stand in front of us, and you will also be sworn in to provide public testimony. If you are in person, please don't also be attached to Zoom. Sometimes this can create some negative interference with the microphones, and we want to hear everyone properly within the city council chambers. And just a final reminder that please only use the chat box in Zoom for logistical questions about Zoom. No public testimony can be reviewed in the chat box of Zoom. Thank you, Mr. Chair. And now I'm going to go over the continuances. We have docket item number 3, this is also a dismissal. My apologies. It is CD BZA 2022-00145, and this is being dismissed because there's no longer a need for a variance. We have docket item number 8. This is CD BZA 2022-00114. The property owner is unable to attend the meeting today, so city staff is requesting a continuance with fee. We have docket item number 12. This is CD BZA 2022-00196, and this is being continued to allow for city staff and the applicant a little bit more time to coordinate with regulated industries. Potentially, this appeal might be dismissed. We just need some more time to work on it. Docket item number 15 is being continued. It is CD BZA 2023. Case number 6, and the property owner is unable to attend today, so they have requested a continuance to March 14th. And we have docket item number 17, 18, and 19, cases CD BZA 2023-10, 2023-4, and 2023-8, and these are being continued for failure to post their property sign. All dates that I mentioned for continuances are recommended continuance to March 14th. Thank you.
Is there anyone in the live audience or anyone in the virtual audience who has any comments on those continuances or dismissals? Board members are entertain a motion to that effect. Ready?
I'll move that docket number 3, which is CD BZA 2022-00145, be dismissed.
I have a motion on that. Can I have a second?
So moved. Second, sorry.
Thank you, Ms. Mixdorf. Anna, please call the roll.
Crosby.
Aye.
Continuance, but
She's the second alternate.
Yes, if I'm busy, I cannot vote, but I don't think I need to vote.
okay, Gorence. Mixdorf,
Aye.
Moran,
Aye.
Stiller,
Aye.
Fitz.
An aye for Ebbets, yes. And on the, so that case is continued to the March, or dismissed, excuse me. And the next case on, then we need to continue, we need to vote on is the docket number 8. Docket 8, case number 114.
I move that docket number 8, case 114, be continued with a fee.
Second.
And I guess that's continued to
March 14th. Yes. I have a motion and a second. Anna, please call the roll.
Gorence.
Aye.
Mixdorf.
Aye.
Moran,
Aye.
Stiller,
Aye.
Ebbets.
Aye. That case continued to March 14. And
I move that docket number 12, case number 00196.
Since these other ones don't have fees, can we call 12, 13, 15, 17, 18, and 19?
let's do all those at one time.
Okay. Okay, I move that docket item number 12, docket item number 15, and 17, 18, and 19 all be continued to March 14th without a fee.
I have a motion, or I've got a motion and a second. Anna, please call the roll.
Gorence.
Aye.
Mixdorf.
Aye.
Moran.
Aye.
Stiller,
Aye.
Ebbets.
Aye. Those are all continued to the March 14 docket. All right, so let's, and so on our docket number 1 and 2, Randy's not part of the, or Ms. Mixdorf is not part of the quorum, so she's going to step back. And Ms. Crosby, you are on for these.
All righty.
So let's call, so again, the quorum for the first case is Crosby, Ebbets, Gorence, Moran, and Stiller. Thank you. And so we're going to call docket number 1, case number 167 with an address of 8128 East 74th Street. Will the applicant please come forward?
Sarah is being promoted and is connected. Is the attorney associated with the property.
Sarah Jane Hunt, here to represent the applicant. I believe Mr. Fish is also online or was going to join via Zoom.
Okay. Anyone who's
They have been
inter-
promoted.
anyone who's interested in this case, please raise their hand to be promoted. Anyone in the live audience?
Carla Johnson has raised their hand.
Anyone else out there?
And from the staff side, Redonda has now joined us.
She's not been sworn in, I don't think, has she? Thank you. All right. Will those people please raise your right hands to be sworn? Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
I do.
Okay, that was the first person. That's city staff.
Redonda,
I do.
Could you state your name, please, too?
Redonda Coleman.
Thank you.
Sarah Jane Hunt, I do.
Thank you, Ms. Hunt. And then we have a
Carla
Mr. Johnson.
Carla Johnson, I do.
Okay, thank you.
Alan Fish, I do.
Perfect. All right, Ms. Hunt, you are part of the committee today, or part of the testimony. There's a listing of docket items labeled 1 to 12 on pages 2 and 3 of the staff report. Do you have any problem with us admitting those for your case today?
I do not.
Thank you. Those are admitted. Part of those is a presentation by city staff on your case. Anna, this is your case. Please tell us about it.
would you like me to go over the case again to provide an update? Or do you want to
I think
jump
just
back into?
board members, do you?
Mr. Chair, given the complications on this one, I wouldn't mind at all if we went back through the full explanation.
Agree.
Understood. I'm going to give a presentation and then Jim Duddy is also going to provide more input on his side from the Development Compliance Division. Okay, docket item number 1. Oh, and let me preface. Last meeting, these docket items were companion cases 1 and 2, but we received some feedback that's saying that we should break up the cases to talk about one property at a time. So this is docket item number 1, it's CDBZA 2022-00167. And this is focusing on 8128 East 74th Street. The current zoning is R7.5, and the applicant is appealing staff's determinations related to issuing a zoning violation about an illegal use on the subject site. As I mentioned that at the previous meeting, this was companion cases, docket items, a number 0.1 and then a number 0.2. And right now we are just talking about the 0.1 of that previous docket item. So this is the subject property at 8128 East 74th Street. It is highlighted in yellow, situated within a residential neighborhood. And the property owner runs a housing a halfway house, we call it a group home for substance recovery and alcohol recovery. And we have identified this use based on their website. more information provided on their website about house rules, further indicating that they're providing housing for recovery from substance abuse and alcoholism. And this is some definitions in our code. So for an R7.5 district, it talks about group homes and how group homes expressly excludes homes for alcoholics, drug addicts, juvenile delinquents, any other prisoners mandated by court. And additionally, a halfway house, if you look at what are homes for those groups of people per our zoning code, a facility for the rehabilitation of drug addicts and alcoholics is still also prohibited in the R7.5 zoning district. So some key points about this particular case and related to this particular property. We do not require this type of use to have a business license since they are a 501c3. Kansas City, Missouri does not permit this type of housing for recovering drug or alcohol addicts in the R7.5 district. The organization proclaims to provide these type of services and this type of housing. On December 13th, the BZA voted to continue this case with fee. This fee has not yet been paid, but we have continued to process this case. We also continued, the Board of Zoning Adjustment being we, voted to continue this case further for development compliance investigation and for legal advice. There was a reinspection that occurred on February 8th of this year, 2023, and the applicant and their attorney did submit some additional documents to city staff on the 10th. So this was past the due date, the deadline that we have to update staff reports. So it has been attached to Compass KC as exhibit number 13. And that concludes my presentation about this particular site. I'll be happy to answer any questions. Thank you.
Thank you. And we will admit exhibit number 13 as part of this case. Thank you.
And Jim, you can approach now. Or give your presentation there, whatever you feel most comfortable with.
Can you bring up the PowerPoint BZA presentation in the final in 9501?
In the Compass KC?
Yes.
Okay, bear with me. Facing or is it in interval?
I can't hear you.
Sorry, bear with us 1 second.
I can go with what I have. Sure. The board, we've spent a lot of time on this case, and there's been a lot of discussion about what is allowed by federal law, what is allowed by city law. But I'd like to review, and I'd like to just kind of remind the board that what we're here for is to determine the appeal and whether the officer erred. If 88-575-09 review criteria, an appeal may be sustained only if the Board of Zoning Adjustment finds that the administrative official erred. If we look at the notice, and we're looking at what is currently the ordinance, which is what our officers judge everything from. It's not a hypothetical situation. It is only what is written in the ordinance.
Hey, Claude, I'm in a hearing.
The notice states.
Okay.
88-805-02-B. This is, as Ms. Manosky showed earlier, the definition of a group home. A group home is single dwelling occupied on a permanent basis by a group of unrelated persons with disabilities. Group homes may also be occupied by paid staff and caregivers. Group homes are typically operated for the care or of developmentally disabled person. It expressly excludes halfway houses for alcoholics, drug addicts, prisoners, or juvenile delinquents, or any facility for individuals under court mandated supervision. Group homes of 8 or fewer mentally or physically handicapped persons with up to 2 additional persons acting as a household. From this is the ordinance. This is what was cited in the notice. So from development compliance point of view, it is just. We are following what the ordinance states as written by the city. It has nothing to do with what the ordinance may say. And if the ordinance needs to be amended, then that should be done and it should be directed from that point of view. But we're looking at whether the officer with development compliance erred in interpreting the ordinance. The ordinance is as is stated, and the notice stated what is according to the ordinance. We also have 88-805-03E. This is the ordinance that covers the halfway house, a facility for rehabilitation for drug addicts, rehabilitation of alcoholics, and rehabilitation of prisoners of juvenile delinquents who are considered to be substance abusers, or for the rehabilitation of ex-offenders in a controlled environment with supervision and treatment or counseling provided on-site on an interim basis after referral from a public agency or institutional facility. On both of these definitions, the plaintiff or the defendant has stated that these are what is occurring at these sites. Again, referring to the ordinance, these are not allowed in our 7.5 districts. The error was not made by our staff. The staff enforced the ordinance as it is written. So when we're concerned about what the ordinance should or possibly say, that is irrelevant in this situation because the ordinance are stated and we have followed what the ordinance states. To go any further, other than looking to see if our officer erred or not, I believe goes outside of the bounds of what we're looking at for the appeal. Thank you.
Thank you, Mr. Deddy.
There was a reinspection done?
Correct.
I haven't heard anything about what was found. And that was my question in the first hearing. What was found there? How many people are living there? Who's
correct? It was originally inspected. The notice was sent for what was found. We found all of what was found basically is what is stated in the definition. There are 8 to 10 people living in the residence. There are people there that are there due to rehabilitation for alcohol and drug abuse. Also, as stated to us on our most recent inspection on the 8th, there are some that are there at the request or following a probation situation. So they're remanded there by the court.
So there were 10 people there when you inspected it?
There were not 10 people. There are 10 occupancies. There are 10 beds. There were only a couple of people at the site, but they did state that is what is occupied at the site.
And up to 10 people.
Correct.
All right, thank you. Any other questions of staff from within or without the meeting? All right, Ms. Hunt. What are your comments on this case today?
Sure. We've already given a presentation. I don't think it would benefit anyone for me to go through that again. We've also submitted correspondence, initially the correspondence related to the appeal and the correspondence that you now admitted as, I believe, Exhibit 13. That was sent after the deadline because the inspection occurred on the 8th, which was also after the deadline. I will just say, based on the comments that I just heard, that I understand that you are attempting to make a decision based on your own ordinance. As the case law I have sent all of you and the guidance from the joint statement between HUD and the DOJ states, you have a responsibility to make and consider reasonable accommodations to your own ordinances. That's what we have asked you to do. As I've mentioned, these are individuals who are both regarded as disabled by Kansas City, as they have been outlined as such in your own ordinance as people in recovery, and also people who have the actual disability of people in recovery, which you can tell based on the rules and application guidelines that you have put in evidence here today. Based on that, these are individuals with disabilities who need this accommodation to live in the community of their choice, which is the whole point of the Fair Housing Act. They also have asked for the ability to live together in the numbers that they are living together, because that is what makes a successful model for sober living. I've again included that on all my correspondence. There has been no evidence submitted that I have heard from the city of undue burden or undue modification of zoning laws. And with that being said, we believe under the Fair Housing Act, the ADA, and the Missouri Human Rights Act, that you have an obligation to make a reasonable accommodation today. I've also pointed out the direct discrimination of your ordinance in excluding people with substance use disorder from group homes. I'm again not going to go into that again. I think we talked about it a lot last time. You've had the opportunity to review the cases I've submitted. And at this point, we've made the request and we await your decision.
Thank you, Ms. Hunt. Are there participants in the audience who want to testify? Please raise your hand and say what you need to say. Thank you. Who wants to go first?
Carla Johnson online has raised their hand.
Okay, thank you. Ms. Johnson, go ahead.
Hi, my name is Carla Johnson, and I testified at the last hearing, but on the other property. I did not realize that these properties were split, and so I don't have a specific interest in this case, but I will in the next docket.
Thank you, Ms. Johnson. Anyone else in the East 74th Street case who wants to testify? Please raise your hand. Is anyone on it?
Mr. Chairman, I'd like to move that we go into closed session
Okay, pursuant to the,
pursuant to section 610-021 parens 1 of the Missouri statutes for legal advice.
thank you.
Second, Amber Crosby.
Thank you, Ms. Crosby. Anna, please call the roll.
Crosby,
Aye.
Lawrence.
Aye.
Moran,
Aye.
Stiller, sorry.
Mr. Stiller?
Aye.
Okay.
Ebbets.
Aye. So we're going to move into closed session and we'll be back in a few minutes. Thank you. All right, I will entertain a motion to come out of closed session.
So moved.
Well, you gotta
We gotta read that.
read
I don't
the.
have it up.
I move that we come out of, oh, we don't have,
Yeah, we do.
okay. I move that we come out of closed session,
Soon?
which we were in pursuant to 610-021 parens 1 of the Missouri statutes.
Thank you. I have a motion. Do I have a second?
Second.
Second from Mr. Gorens. Anna, please call the roll.
Lawrence. Moran,
Aye.
Stiller,
Aye.
Crosby,
Aye.
Evans.
Aye, we're now back into open session. We've thought a lot about this case and we've discussed it many times. Ms. Hunt, you have a valid reason given the federal statutes. Mr. Duddy, you also have a valid reason because your city staff and your enforcement division did exactly what this ordinance asks you to do. So we're kind of at a conflict, and that's what Board of Zoning Adjustment does sometimes, is accommodate conflicts, both on the city side and in the applicant side. City board or board members, do you have some more comments? Mr. Stiller or Ms. Crosby? Lawrence or Ms. Moran?
Yes. Amber Crosby. And my comment is that I believe in deferring to the city ordinances and codes as written. And I reiterate what the chair has said so eloquently regarding our staff doing exactly what they were supposed to do in accordance with the ordinances as they are written. And so want to make that clear that is my position as well.
Thank you, Mr.
Yes,
Crosby.
Mr. Chair, I agree with your comments, exactly as you stated.
Thank you, Mr. Stiller. Anyone else?
You agree with yours?
Okay. Ms. Hunt, do you have any other comments you'd like to make?
None.
Okay. And anyone else in the audience, either live or in virtual, that wants to make other comments? And if not, we'll entertain motions if I don't hear from anybody else.
I have a motion.
Oh, yes, Ms. Moran?
Mr. Chair, in docket item number 1, I move that we grant the appeal and accommodate this household accommodate this use in accordance with 88-810-700, the definition of household, which allows a group home for 8 handicapped persons, which may include 2 additional persons acting as caregivers, so that we allow an accommodation for this home to have 8 handicapped persons and 2 caregivers. But also that this accommodation requires that New Beginnings Sanctuary be fully responsible for the conduct of the residents of this home. And if there are problems and neighbors call in with problems, that they will take care of any problems, whether it's the behavior of the residents, parking, the condition of the house, whatever problems there are, this organization should be responsible for them. But this accommodation would allow them to have 8 handicapped people and 2 caregivers in the house.
It's a long motion, but fully understood by me. Does anyone, and can I get a second on that?
Second.
Thank you, Mr. Gorens. It's a long motion, but it fully understood by me and I hopefully by Ms. Hunt as well. Can I please have Anna call the roll?
Lawrence.
Aye.
Moran,
Aye.
Stiller,
Aye.
Crosby,
Nay.
and Evans.
Aye. So that motion, we've granted the appeal, and that's that. We're by agreement, it's 10:15. We have to give we'd like to give city staff a small break. I know we've spent a lot of time on this case and we'll get to everyone else's right after this short 10-minute break. Okay with everybody? Yes?
The point of clarification, are we going to be doing another presentation for the other property, or is this for both properties?
No, it's just for this property in docket number 1, case number 167.
Okay.
Thank you. All right, we're going to take a short break. off of the break. We're going to call docket number 2, case number 173 with an address of 9501 Manchester Avenue. Will the applicant please raise their hand to be promoted? I'm guessing that's Ms. Hunt again. And who do we have in the virtual audience that I have not sworn in yet?
I was sworn in the last case. Do I need to be sworn in on this one?
No, you're good.
No one else online has raised their hand.
All right. Ms. Hunt, in a similar situation, we have administrative exhibits 1 to 12, and there may be a 13th exhibit that I don't know of yet, that we don't know of yet, to be admitted in this case. Do you have any problem with us admitting these exhibits for your case today?
I do not, but I would ask that that exhibit 13 be applied to this one because the first hearing was for both, I didn't distinguish the properties.
Right.
So it seems like that would be relevant in this case too.
Perfect. So the exhibit 13 will be admitted. And we do have some live people in the audience. How many people are in? Don't come up yet. I just want to know how many people are either in the audience who are on this case. Please raise your hand or. All right, there's quite a few.
We're not all going to speak though.
I understand that. And anyone, those are all in opposition. Anyone in favor of this ordinance? Okay, or this case. All right, and the speakers, if you'd like to come forward, I'd like to swear everyone in, and then we can, I don't want to hear your testimony yet. We're just going to swear you in and get a name. So will you please raise your right hand to be sworn? Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
I do.
And could you state your name for the reporter?
Alonda Cole.
Perfect, Ms. Cole. And
Mary Barnett.
thank you, Ms. Barnett. We'll get testimony from you in a minute. As I said, part of this is the staff report from Anna. Do you want to kind of like the other case? Would you like to review that with us, please? Thank you.
And Mr. Chair?
Yes.
I have submitted a request for a continuance on this matter, so I don't know if you want me to wait until after all that's done to address that.
Let's see here.
I saw the filing, the 42-page document that was filed on Friday, on Monday. And certainly, as you're aware, I represent Hickman Mills School District. I received authority from the district last night to respond to this. And obviously, there's no way that I can respond to a 42-page document that was filed on Friday for a hearing that's on Tuesday. So I'm going to be requesting time to be able to decipher that and provide a written response to that.
Well,
This is Sarah Jane Hunt. I would object to that. It's my understanding that the school district indicated last time that they would be submitting a brief. They have not done so, or at least I have not received anything in that regard. This has been continued. They are not a party to this action. They don't necessarily have a right to respond to my documents that I have submitted to the BZA. And again, as I mentioned before, the reason why we submitted that correspondence was in response to the inspection that occurred on the 8th of February, which is why it was submitted after the 8th of February. Of course, you all can make the decisions you wish to make. However, any continued delay would be highly inappropriate. And again, it's just sort of propounding the discrimination that we've alleged in this case. But again, I respectfully leave the decision to the BZA, as is your right.
thank you, Ms. Hunt, for your testimony.
And in response to that, I saw this document filed on the 10th. So we haven't submitted a response because this is more than just a response to the inspection. The document is 42 pages long. It includes numerous cases. It includes, a legal argument for why they feel like they're being discriminated against, that the district has an interest in responding to. This house is less than a half a mile from one of our schools. Our board voted unanimously last night to have me address this. And the reason for that is because they've got a strong concern about the safety of their students. And I can't, regardless of what the rationale is, I cannot be expected to respond to something that was filed on a Friday when we're now at Tuesday morning.
And again, I guess I'm confused as to what right the district has to respond to anything. If the district is seeking to interfere in the housing rights of my clients, then they too are subject to the requirements of the FHA and the ADA. And that can be something that we handle between us. But I don't know what
but it's being handled
the district
here.
has to oppose or respond to anything that we are submitting to the BZA. This, again, as a lawyer, this is all case law. As you can see, most of the cases have been in circulation for a very long time. The Fair Housing Act was amended in the 80s to include individuals with discrimination. Any person with a primer on any sort of law should be up to date on this. The arguments we're making, and this should come as a surprise to no one.
Ladies, thank you very much. I'd like to ask our board members if you feel a continuance is appropriate here or not. Okay.
Right. I would hate to make the folks in the audience come down again, but could we hear from all the witnesses that are present and online, and then possibly continue to a month just for the final decision and allow the school district to submit their brief if it.
So Ms. Hunt and Ms. Johnson, did you hear what was said here? So we're going to go ahead and hear the case. And then at the end, if you feel like you need to make a request to continue after you've heard the testimony today, then we will possibly consider that request. But at this time, we're going to proceed forward with the case. So Anna, please proceed.
Docket item number 2 focuses on CD BZA 2022-00173. The subject site in question is 9501 Manchester Avenue, also zoned R7.5, and the applicant is seeking to appeal city staff's determinations related to issuing zoning violations about an illegal use on the subject site. As previously mentioned, these cases were previously combined as companion cases on the docket. Now we have split it up. We're talking about the second site in question. This is a close-up of the subject site, 9501 Manchester Avenue. It is highlighted in yellow, situated within a residential neighborhood. Same property owners, same website, same content as the previous case. There is a housing group home, halfway house located at the subject site for individuals who are recovering from substance abuse and alcoholism. Again, the house rules also found on the property owner's website. They operate several of these facilities in the city and in Missouri. Again, same definition cited by the zoning and development code. Group homes in our existing zoning and development code expressly excludes homes housing for alcoholics or drug addicts, other people who have previously been in jail who are court mandated to these sites. Additionally, those are prohibited in R7.5, as well as halfway houses, which specifically identifies that halfway houses are for the rehabilitation of drug addicts and alcoholics, also prohibited in R7.5. Same key points as the previous case. The property owner is a 501c3, so they do not need a business license. The existing zoning and development code for Kansas City, Missouri does not permit housing for recovering drug or alcohol addicts in the R7.5 zoning district. The organization self-proclaims to provide housing for these individuals. In December, we had a continuance, which was attached with continuance with fee. That fee has not been paid yet for either case. On January 10th, the BZA voted to continue the cases again for the development compliance investigation, which has occurred, and to seek additional legal advice. As I mentioned, the reinspection did occur. And Jim Duddy, the supervisor of that group, can provide additional details about that investigation. And then the applicant, Ms. Hunt, has submitted additional documents on the 10th, which was uploaded to Compass Casey, since those items were sent to me after the deadline for the staff report revisions. That concludes my presentation about docket item number 2, and I'll be happy to answer any questions. Thank you.
Mr. Duddy, will you please give us your comments on this address on Manchester, please?
Site was re-inspected. It was also found to have 10 beds within the residence. Again, I would like to go over 57509, the review criteria. An appeal may be sustained only if the Board of Zoning Adjustment finds that the administrative official erred. As we have gone over the definitions previously, the city definitions on what was stated in the notices of violation as the ordinance is violated are just and as written by the city. Again, it's not for my officers to try to interpret what they should or should not interpret as the ordinance, but as the ordinance is written. They did enforce what was written as is written by the city.
Yes, yes, sir. And thank you very much for your testimony today. Ms. Hunt, why should we?
Sure. And I know that there's so many people waiting for their cases to be heard. So I want to keep it brief and basically, if I could, incorporate my argument from docket number 1 into this matter, which is in a briefer sense than I said before, that once again, I understand that you all are looking at the 4 corners of your own ordinances, but under the Fair Housing Act and the ADA and the Missouri Human Rights Act, a reasonable accommodation can and has been held to include accommodations from your own municipal ordinances. In this case, once again, this is another house that has the same model as docket number 1. The individuals in the home are both regarded as individuals with disabilities and individuals who have actual disabilities, which is that they are in recovery from drugs and alcohol, and their recovery impacts one or more major life activity. Again, I haven't heard any undue burden on evidence on the part of the city or any argument that this would be a unreasonable modification of your zoning plan. With that, I leave you to your decision, and again, incorporate both the arguments from my previous case and the documents that we have submitted in this matter. Thank you.
Thank you, Ms. Hunt. Also, is it your testimony no more than 10 individuals will be in this home on Manchester at any one time?
Correct. Residing there, of course, people might come.
Of course, visitors
Right.
excluded.
But residing there, it would be 10.
Okay, thank you. Ladies in the audience, please come forward and give us your testimony, and then we'll hear from Ms. Johnson as well.
Thank you for.
Could you
hearing
please
us
identify
today.
yourself one more time?
Yolanda Cole.
Thank you, Ms. Cole.
Thank you for hearing us today. I'm not going to add to what I presented at the last meeting. I'm not going to repeat it, but I will add. Number one, the difference of these 2 properties is that our particular neighborhood is populated densely. If you look at the shot online, then our neighbors are very close to each other. She stated last time that the properties were purchased in April. Our property was not purchased until August. September the 2nd, we immediately contacted the city of what we were seeing. There have been some added activities in our neighborhood where I have contacted the police and have asked for additional patrol for our safety because there have been cars that we normally don't get. I live at 95th Terrace, so it's only 4 houses on our block and it is busy. We have had, and we traced it, that they have some automobiles, particularly a white SUV that is not in good working condition, which has a very bad muffler. If you notice, that house lives right there on the corner, but they decide to drive through our neighborhood at different hours of the night, and we are disturbed as neighbors. So that has added. We have seen added activity, especially from the last time when it was appealed, additional activities in that house that our condensed neighborhood has not had before. Also, I know we're dealing with the ADA and the American Housing Act. Our homes have handicap too. We have one person here who takes care of her son. So to say that you're being not fair to the handicap is not warrant, because our homes have handicap people in it as well. And also in the Fair Housing Act, through the Department of Justice, which I have contacted Washington, D.C. and explained to them this and have sent them information, and they're waiting for my response. In it, it says discrimination in housing based on race or color. Our particular neighborhood is minority, and our homes, the lowest house sold for $225,000, and that was the house that they bought. The other homes have been selling for $240,000 and up. So we're a middle class. There is no bus line. So like last time, he said some of them cannot make it through the program. Where do they go? We have a park. We have 2 schools. We have a daycare. Where do they go in our neighborhood? They walk our neighborhood. And also, as far as the Fair Housing Act, in dealing with discrimination in housing based upon disability, it says that if you are threatened of life or property, that the alcohol and drug addiction does not apply. We're threatened. These people don't necessarily go through that 12 process. Where do they go? We're already seeing added activity. We have already had to call the police and ask for additional patrols. We're threatened. If any, close your eyes. When you close your eyes and you vision your home, your neighborhood, you feel like this is where you lay your head. The home is your most expensive that you buy. And it's where you want to feel safe. Your children feel safe. Your grandchildren feel safe. And your other family members feel safe. And we're pleading with you. We know what you have decided with the other one. No one was here for them. We went and visited that property. There's not a lot of housing around that property on 74. It is not condensely populated as ours. The lady who their fence share each other, she's worried. We're worried. We're not new to housing, to homes. We've been in our home for 28 years. Our home is paid for. We're retired. We're not looking to purchase someplace else. We have raised our children where our grandchildren come. We're threatened, seriously threatened of this because of what we are observing. We're not threatened because we might have a stereotype idea of them, but we're threatened of what we are observing, our peace of our neighborhood, our safety of our children. Because if they're out of that program, as I stated, and I apologize if I'm repeating myself, where do they go? There's no bus line. There's no business nearby. My husband walks our little beagle at the park. Well, he noticed there was a car and another gentleman. He stopped walking our little beagle. We shouldn't have to do that in our homes. So we're pleading because this situation is different. And yes, our rights as fair housing, our rights as with disability are also at stake. And we're saying, take into account that as well. I want to thank you all for listening to me.
Thank you, Ms. Cole. Thank you so much.
Mr. Chair, can I ask one question?
Ms. Cole,
Yes.
just for a question.
Could you be more specific? You said that there's been added activities and you talked about calling the police. Could you be more specific? about the
Yes,
activities you've
where
seen?
my house is, I'm on 95th Terrace and I'm retired now. And you know, we retired people, we're kind of nosy, so we look out the windows all the time. So I know the activities in our neighborhood because the neighbors, all of us, we watch at each other. If they're going out of town or whatever, we watch for that. And we notice there's been a lot of activity, a lot of more cars. We also notice at that particular house, it's usually several cars parked there, which that's fine. We're not, because we park. But however, when you're not maintaining your car and you're driving through the neighborhood, when you can come right to your house, we're wondering, what are you doing? Are you watching us? You see, so we're threatened because we haven't had that type of activity. All right. We understand people need to be rehabilitated. We understand that. However, our neighborhood is condensely populated. It's different than the other one. We have children, young children. There it's not a high school, it's 2 elementary schools. Very personable. The school bus picks them up right there on the corner. And if they don't, they walk. I see them in the morning. The school bus pass 8:30 every morning. And I see some of the kids with their parents walking them. They have to pass that house. They have to pass the house. So I'm just asking to please. Any other questions that anyone has for me? Thank you.
We hear from the other lady, please.
Yes, my name is Mary Barnett.
Yes.
We're here today to ask you to enforce your laws, enforce your codes. The city needs to enforce their codes and stop amending them and letting investors come in from out of the area, purchase houses, have no one here to maintain them. We have a ton of them in our neighborhood, strip malls, housing that's not properly cared for. I've had one next door to me for 10 years because the city does not enforce their codes. Codes need to be enforced as they are on the books. We pay taxes. Your out-of-town investors are fly-by taxpayers. I think the city needs to appreciate the taxpayers of this city and enforce the codes that are on the books. I have worked in property management for over 30 years. Fair housing accommodations does not include drug addiction and alcoholism. That is not fair housing accommodations. Thank you.
Thank you so much, Ms. Barnett. I appreciate it. Anyone else want to make any other comments? Please come on up, sir. I've got to swear you in and please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
I do.
Could you state your name for the
Yes,
court?
my name is Kelvin May.
Mr. May, go ahead and tell us your testimony.
Okay. My neighbors here, we are deeply invested and care about our community where we live. And it's kind of a slap in the face for what the attorney for the plaintiff is saying, that well, we need to accommodate these other folks. And the school district doesn't have a role or a buy-in. Yes, they do. This is our community. They're concerned about that. Now, we've been to this, we spent three Tuesdays of our time coming here. And we reserved other cases. One of the ones that we saw earlier was something similar, but it was in a different neighborhood and it was different zoning. But that was denied rather. They denied that. But this case, the earlier case, because of the community they're in, that was just approved by you guys. I hope that's not going to be the case for this situation. Again, we care about our community. If we didn't, we wouldn't be here. Now, it's unfair to say that, oh, well, there was an extension added on because the lawyer on this case, she said she didn't have a whole lot of information. Then you guys approved an extension on that. Then the lawyer for the school district asked for that, and he said, no, we're going to move on with it. It just doesn't seem right. It doesn't seem like you care about what our neighbor just said about the taxpayers and the people that care about the community. We've invested, we've been in our neighborhood, some of us been over 30 plus years. And we're just bonded as neighbors and as a community. If we didn't care, we wouldn't be here. So we're asking you to support us as taxpayers, as community loyalists. That's what we're asking for. That's all. We just want respect. We want respect. That's all I have to say.
Thank you, Mr. May. I do appreciate it. Ms. Barnett, another quick comment, please. Thank you.
Thank you. I also would like to say that this company came in disregard to the codes and the laws that we have in our community and opened up this halfway house unknown to the community, unknown to the neighbors, unknown to the school district that has a bus stop on that corner. Even though they're rehabbing from drug and alcoholism, what are the other things that they have been charged with? Their paroles? Are they on parole? Do they have parole violations? Are they sex offenders? The focus here is on drug and alcohol. Everything needs to be investigated. Thank you.
Thank you. Thank you again, Ms. Barnett. And Mr. May, just a real quick comment to you were here at the last meeting. That was for a special use permit for a halfway house for a prison, much more than 10 people. And that was out by the airport. So that was denied. Your cases and the case before you, sir, are totally different. It's 10 people or less in a home. And so we have to uphold our ordinances too, in respect to federal law that governs the people that are handicapped. And alcoholism and drug abuse is a handicap as defined by the federal laws of our country. So I very much respect everyone's opinion today. Ms. Cole, Ms. Barnett, and Mr. May, thank you very much for your testimony. Thank you. All right. Board members, do you have some more comments? And don't forget, we have to think about the continuance request as well.
And I do have additional comments that I want to provide in addition to my request to support my request for a continuance.
Yes, Ms. Johnson.
Are you ready to hear from me?
Yes, please. Thank you.
Thank you. So I'm requesting the continuance for two reasons. Well, primarily for the reason that I feel like, and the district feels like, the community, the individuals in the community that are here are lay individuals, that are here testifying are lay individuals. They have been met with a legal argument, a technical legal argument that this commission is getting advice on, and they're hearing one side of that argument. And so to be able to provide the additional side to that argument, I would like the time to be able to do that. You know, you have, there are two reasons. One, first, there's an argument that's been made by counsel for the appellant that these individuals should be treated as a family and that they should be considered disabled under the Federal Housing Act and under the ADA. However, there hasn't been any evidence presented to support a determination that these individuals are disabled. We don't have any information at all about these individuals. And so, you know, making a decision to treat them a certain way without having any evidence that supports the notion that they in fact have a disability of any sort, other than just, you know, counsel saying it. We haven't heard from any of those individuals. We don't have any evidence that supports a disability for any named individual that's living in that house. Number one. And number two, so, you know, she's asking for a reasonable accommodation. There's a process in the law for addressing a request for a reasonable accommodation. And that is that if the zoning board can offer a legitimate non-discriminatory reason for its housing decision, and there's been plenty of evidence that supports a non-discriminatory reason for a housing decision, then the burden shifts back to them to show that this isn't a pretext for discrimination, that the city's decision isn't a pretext for discrimination. These are all highly technical legal arguments that you all need to be able to have the opportunity to hear both sides of. If you're going to consider a 42-page document and make a decision based upon advice from legal counsel that you went in closed session to obtain, then you should be able to hear both sides of that argument. There is clearly a non-discriminatory reason for the city's decision to zone the way they're zoning. The city has provided a legitimate basis and a legitimate opportunity for individuals that want to maintain a halfway house to be in a zoned area where that's acceptable to do. This area is zoned residential, and for the reasons that the individuals who have already testified today so eloquently said, it impacts their quality of life. That's why areas are zoned residential. They're giving you the evidence and the reasons for a non-discriminatory reason for making a housing decision. And then the burden shifts back to the plaintiff to show that what the city is really doing is just a pretext for discrimination. That analysis needs to be made. The Hickman Mills School District has met in closed session last night to address this issue. They have given me the authorization to prepare a written response and to argue this. And I would respectfully request the opportunity to be able to do so. They are concerned about the community. They're concerned about their students that go to school right around the corner within walking distance that have to walk past this house. They're concerned about that. And so I would respectfully request the opportunity to be able to present the converse legal argument to the 42-page document, and I can't do that today. So I'm asking for a continuance to give me the opportunity to be able to do that. I'd ask this hearing be continued to next month for a decision, and I will ensure that you all have timely our written response.
Thank you, Ms. Robinson. And of course, we can't ask for names. You know, HIPAA prevents us from asking for names and public testimony of people with abuse issues, alcohol and or drug. So I cannot ask the Ms. Hunt to give us names. It's her testimony under oath that she has said that there are only 10 people, 8 and plus 2 caregivers in this home on Manchester. If there's an 11th person in that home, that's in violation of our ordinances.
Well, respectfully,
yes,
Mr. Chair, respectfully, this whole request is outside your ordinances. I mean, you've got ordinances that are in place that the community is asking you all to abide by. And so, you know, you're making exceptions to your ordinances. You did that on the last case. So, you know, I hear what you're saying, and certainly there's a way, if we were in a court of law, there's a way to get testimony in so that testimony is protected. I mean, that's the purpose of a protective order. So, you know, again, and it's difficult. What's most challenging about this is that we're arguing very technical legal arguments outside of a court of law, and you know, you're being asked to make a decision without the proper experience to be able to do that. I appreciate the amount of time that you all do volunteer as lay individuals, but this honestly is an issue that ought to be litigated in a court, not before this board. And so it is challenging to be able to address these issues this way. I am trying to work the best that I can with regard to this, but honestly, this seems highly inappropriate for this board to be even having to consider this question. This is a question that if council wants to file a lawsuit, should file a lawsuit, but this is not, you know, you're not.
Do I get an opportunity to respond just briefly?
Briefly, please, Ms. Hunt. Thank you.
Yeah, so under the Village of Palatine, which is a case out of the Seventh Circuit, it sets out what individuals like my clients are supposed to do, which is that we need to come to the board, let them know what the discrimination that we see is, and allow them the opportunity to rectify the discrimination within the confines of their own processes. Now, obviously, every board, it's a little different. And I have to tell you, I've been in front of many of them. And there's, of course, very rarely, if ever, a procedure by which a reasonable accommodation is considered. Actually, that usually only happens after we do get a denial, file suit, and then work on a settlement agreement together that sets that process out, which was the consent decree I sent you from the Village of Hinsdale. The other thing is it's not just about actual disability, right? Like that is one way that a person can be covered under the ADA. The other way is being regarded as having a disability. And there's a unique issue here in this case, which is your ordinances specifically exclude people with who are recovering from alcohol and addiction from your group homes and kind of sideline them to only one part of the city, which again, I understand you all probably didn't write that ordinance, but that is, I have to bring it before you, that is discriminatory. And because you regard the reason we're here is because you regard my clients as people with who are recovering from alcohol and drugs. So that's why we're here.
Ms. Hunt, if you don't mind, if you excuse me, please, and Mr. Chair, I'm asking for a point of order here. It seems that from what Ms. Hunt just described is the reason why Ms. Johnson is asking for a continuance. We are discussing case law that was presented on Friday that I'll tell you as a board member, I did not know that it had been placed in Compass on Friday as well. I saw it this morning. And this is the exact reason why that there's been a request for a continuance. I know I personally wouldn't be able to make a decision on this without having appropriate time to evaluate what has been presented and what will be presented by the opposition. But this is not something that I would feel comfortable with this board moving forward with,
but I do
based on these topics.
Based on your own procedures, we do get a chance to rebut. And as I understood it, we are proceeding with the hearing today. And then after the evidence is in, you are going to make a determination whether you have a continuance. So I would just ask that I be able to finish my argument.
Our board chair said the testimony of the audience, not argument. Again, the request for continuance is based on argument. We only agreed as a board that we would hear those who had taken the time today that are concerned citizens and that are either in opposition
right, but that's not what
or
you
in
did.
favor of.
You heard from your staff, then you heard from the opposition, then you heard from the school board. And at this point, if you're telling me that under your own rules, you are not going to allow us under the opportunity to rebut, you can do so. I just ask that you do it on the record.
Ms. Hunt, we are not a court. As Ms. Johnson mentioned, and in my opinion, is your appropriate forum for the arguments you're making is a court. not this board. However,
And
I'm
what
not
I'm
the
telling you
board.
is
I am
we
not the
will
board.
Ladies,
pursue this.
ladies, talk
We
one
will-
at a time.
Right, and again, I think it's my turn. You made the process very clear last time. It would be very inappropriate to change that process because Ms. Crosby doesn't like my argument. The thing is, we have every intention of taking this to court. That's why we're here. But the first step before we sue is to ask you to do the right thing. If you don't, then we sue. That's the legal process. You have your own lawyers. You have no obligation to rely on the arguments of a lawyer that practices school law. If you want to do that, you can. I will remind you that she indicated she would submit a brief this time, and she did not do so. If you're going to continue to delay this, that is fine, but please note that there are consequences under the law for continued discrimination. The other thing I would note in my rebuttal is that my clients have never been cited for any noise violation, any parking violation, or any criminal violation at all as it regards to their residence at the property in question. What I have heard today is, again, evidence based on stereotype. That is not permitted under the law. At this point, if you want to continue it, that's fine. I'll be here. But I think that it's inappropriate, and I think it's continued delay that has consequences for my clients and the people that they are trying to help.
Thank you, Ms. Hunt.
And let me just say this, I'm not sure what the consequence is because the families are living in the house right now. So I don't know that what consequence there is to a continuance. Your client's position is not being changed by providing me 30 days to respond to your 42-page document. There's nothing that is changing the position of the individuals who are living in that house right now over the next 30 days.
Thank you, Ms.
Johnson.
Johnson, sorry, thank you.
Okay.
Ms. Crosby, please continue your statement as well. To go.
Thank you, Mr. Chair. I remain on the record as stating that I believe a continuance is appropriate in this case, given the developments that have occurred between February 8th, when there was an inspection, February 10th, when documents were posted to KC Compass, and today. I believe council has requested that continuance. Our board determined that we would, out of deference to the time that the audience, that neighbors and community members have taken to voice their opinions, we've chose to hear them today and also have the option, gave ourselves the option to then grant a continuance or vote on a continuance in order to give all parties time to review the documents that are in evidence and also to submit any rebuttals. And that is, I remain in support of that. And if the chair would entertain a motion for a continuance, I present as such right now.
Mr. Chair, can I ask something?
Of course.
Ms. Johnson, can you provide a brief within 2 weeks so that the Ms. Hunt has a chance to respond before our next hearing and it doesn't get delayed again?
Yes, I can respond within 2 weeks.
Okay, I would ask that if any continuance be conditioned on Ms. Johnson responding within 2 weeks with her brief, and then Ms. Hunt being allowed another week to file some kind of reply to that, so that we'll have these documents ahead of time and can review them.
I agree with what Ms. Moran just presented.
Ms. Hunt, do you have any other comment on that request that you review the document after receipt and respond so that we have all our documentation on this for this board meeting on March 14th, if a continuance is granted today?
I continue my objection to the continuance based on the reasons I've already given. And if the board chooses to grant it and require me to file a reply within 1 week of receiving Ms. Johnson's response, I will do so.
Thank you.
I wasn't saying require you to file a reply, but if you would like to file a reply, I would like to get it within a week after Ms. Johnson submits.
Yeah. Understood.
And of course, Ms. Johnson should copy Ms. Hunt on whatever she submits.
Perfect.
And I assume that I can contact, because I'm not familiar with the process for filing something. So who do I submit this to?
Ms. Johnson, you're going to submit the document to me. I'm going to attach it to the case in Compass KC for all parties to be able to review publicly.
Okay, and who is, I'm sorry, all I see is something that says public testimony on my Zoom, so I'm not sure who I'm speaking with.
Yeah, I will put my email in the chat box. I am the planner attached to this case.
Okay, thank you very much.
Remind everyone online and in the audience that your testimony was heard today. It will be responded with consideration and respect. And if this case is continued, you're welcome to come back again, but only if you have new testimony that we haven't heard before. So, Ms. Crosby, did I hear you have, well, first of all, any other comments from anybody? Yes, Ms. Cole, come on up pretty quick and
we feel extremely passionate about this. We are willing to do Court of Appeal.
of course, yes.
But we want that on the record so she'll know, yes, we will file Court of Appeal if,
Of course,
if this is up, if
of
they don't.
course.
Thank
And that's your right.
you. Okay.
Yes, sir.
You need to come up.
Yeah.
Hold on, you got to swear you in.
I sure didn't.
It's okay.
Well, I don't go to jail that often, so.
Okay,
Go
please
ahead,
raise your
sir.
right hand to be sworn. Do you solemnly swear to tell the truth and nothing but the truth during this hearing today?
Yes, sir.
Please state your name for the court reporter.
Lee Nelson Senior.
Lee Nelson Senior. Thank you,
Yes, sir.
Mr. Nelson.
And the reason why I come forward today, I actually worked for that school district. And I know how they operate. I'm sorry about this, but when I was working for them, it was just the opposite. They didn't want African Americans in there. Now, all of a sudden, they want to change things about the community. Hardworking people like us don't want to pick up and move.
Right.
We want to stay where we are. And I believe in everything in my heart that it's going to come out well with us. Because I know that there's some people in this city, in this county, who knows what we are going through. And I believe that if any one of you had to move next to where there's 10 people in a house, you're going to move. You don't have to answer it because I know you will move because you want your family what? Safe. And that's what we're arguing about, staying safe. And I appreciate you listening to me, but we want to be safe in our homes. Thank you.
Thank you, Mr. Nelson. Board members, any other comments or questions?
I guess I'd like to clarify so Ms. Johnson will file any brief that she chooses to file by the 28th of March. And then Ms. Hunt will file any reply brief that she chooses to file by the 7th, or I mean, the 28th of February and then the 7th of March. I just want to make sure we've got all that on the record so we get these in a timely fashion.
Sorry, it's my understanding that the next meeting would be on the 7th of March, or is it on
March
the
14, Ms. Hunt.
March 14th? I already know I'm out of town on the 14th. So I was thinking it would be on the 7th. So if a continuance is granted, I guess I would ask that you do it in April. I have not held my calendar, in perpetuity, thinking that this would be concluded today.
April 11 would be our meeting in April. Would you be willing to meet virtually on this day like on March 14?
No, I'm going to be out of the country, actually. I don't have any faith in that. Sorry.
I know it's spring break.
Yeah.
All right. Board members hearing that, any motion you would make either to continue the case or vote on the case would be reflected for the April 11 docket. Anyone for motions?
Amber Crosby, I move that we continue, hang on, make sure I get the case number right. That we can continue case number CD BZA 2022-00173 to the April 2023 BZA regularly scheduled hearing.
Which is April 11th, Ms. Crosby.
April 11th, 2023.
Thank you.
Yes, sir.
I have a motion. Do I have a second?
Second.
Anna?
Second.
Yeah, we've got it. Thank you. Seconded by Mr. Gorns.
And if I may, before you all vote, if we're going to extend this to April, can I have until the 4th to submit my response? I was concerned about being able to do it in 2 weeks, but just because of my own personal calendar.
Sure.
All right, thank you.
Gorns,
And then the reply to that
A
would be,
reply would be a week later, if that suits Ms. Hunt.
Moran,
aye.
Stiller,
Aye.
Crosby,
Aye.
Ebbets.
Aye. This matter is continued to the April 11th, 2023 docket. And again, thank you very much, testimony givers. We appreciate it. All right. Let's move on to docket number 4. Wait, I've got to go get 5. Right. I've got to get our other first. She'll be out here in a second. Oh, and you need the juice?
Yep.
Well, you got, yeah. Hey. You ready? Almost. Let's call docket number 4, case number 58 with an address of 331 West 77th Street. Will the applicant come forward or raise your hand to be promoted in Zoom?
Jane,
Kuhn, yes.
where'd they go?
Anyone else in there?
Jane is not connected yet. There they
Okay.
are. 1 second.
Sure.
You need to accept the promotion. Ms. Kuhn. They are connected. No one else has raised their hand.
Good morning, Ms. Kuhn. I'm lost right now, but I'm there. We have I got to swear you in first. Please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
Yes, I do.
Please identify yourself to the court reporter. Thank you. In your proposal, in your docket today, or proposal today, we have a list of administrative exhibits labeled 1 to 9 that we need to admit in order to hear your case today. Do you have any objection to that? I didn't hear that. Ms. Kuhn?
Yes.
Okay. Do you have video or just audio today, ma'am? Ms. Kuhn?
Yes. Can you hear me?
I can. Do you have video as well or just audio?
Yes, my video is turned on. You don't see me?
No.
I'll try turning it off and on again. Can you see me now?
Perfect. Thank you.
Okay.
I'm going to swear you in one more time. Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
Yes, I do.
And state your name for the court reporter.
My name is Jane Kuhn.
Thank you. There are lists of administrative exhibits labeled 1 to 9 found on page 3 of the staff report. Is it acceptable to you that we admit those exhibits for your case today?
Yes.
Thank you. Part of that is a presentation by city staff on your case. Anna, will you please present the case? Thank you.
Certainly, thank you. Docket item number 4 focuses on CD SUP 2022-58. The site in question is 331 West 77th Street. The site is zoned R 1.5. The applicant is seeking approval of a special use permit for a short-term rental. The subject site is in the Waldo neighborhood of Kansas City, Missouri. And this is an image of the property in question from Google Street View. It is this little yellow house here on the corner, and you can see Warnell in the very back there. So there are several instances where someone would need a special use permit to get a registration for a short-term rental. But in this case, the triggering factor is that adjacent owner consent form that is required with short-term rentals. An example of properties that would need a signature for said adjacent owner consent form is on the screen. You can see a highlighted example and then all of the properties around it in green that a hypothetical property owner would need. If this property owner could not receive 55% of those adjacent owner consent, another avenue for approval is receiving a special use permit through the CPC and this body. In this particular case, we see the subject site highlighted in yellow, and then there are only 2 residentially zoned properties adjacent to this property due to the unique lot shape. One of them, which they have received signature for, which is the apartment building next door, and then that only leaves one other property owner in question, so they can either receive 50% or 100%. This is a unique situation where there really is no possibility for the 55% or more. Thus, this application. The approval criteria associated with a special use permit is on the screen. The review criteria that is most applicable to this particular STR review is D. Is this use compatible with the neighborhood and the surrounding area in terms of like hours of operation, lighting, noise, etc. And city staff believes that a short-term rental in this particular location is pretty comparable to the existing land use. When you look at if this was a regular owner occupied use or even a long-term rental, so for someone to rent the property for like a lease for a year or more, pretty comparable. How many people can be on the subject site, how many cars can be on the subject site. And there's also the additional criteria that an STR has to maintain per our code in 88321-4, which talks about how many guests they can rent out to, how parties can't be hosted on the subject site, etc. So if approved, this site would also be subject to that same development compliance investigation to ensure that it is following those criteria identified in the code. Thus, the CPC recommended approval subject to conditions, and they did modify one of the conditions originally presented to the CPC, that the special use permit attached to this property, instead of it being renewed every 3 years, it would be renewed every 5 years. That concludes my staff presentation. I'll be happy to answer any questions. Thank you.
Thank you.
I've got a question for Anna. Is 5 years a new standard that we're trying to go toward? Is that why the CPC kind of went to the 5 years instead of 3, or what was
Due to the property owner's testimony, the CPC changed the condition from 3 years to 5 years.
Great. So that's not necessarily a new standard that we're seeing moving forward, just in that condition.
In this particular instance.
Okay.
Want Anyone else have any questions? I've got one. Ms. Kuhn, how many other short-term rentals do you have in the Kansas City area, Kansas City Metro?
0. This is the only house that I own.
And it looks like you're based in California, I think. That's where I saw the address.
Yep, it's a season of transition. My family lives in Kansas City. I purchased this house last fall to be closer to them. I work remotely and travel a lot for work. So right now I am not fully based in Kansas City, but would like to be able to stay in the home, visit with my family, work remotely, even though I'm not there full time, and to be able to rent it out when I'm not there. That's what I'm hoping for in this current chapter.
Understood. Thank you. And do you have any problem with the couple conditions that were set aside by the City Plan Commission? One is which revised plans are required and upload those plans up to final action. And then lastly, it was for a 5-year period.
No problems with those.
Okay. Board members, any other questions?
Do you know if there are any other short-term rentals near your property?
Just from my informal research of looking at those listing sites like Airbnb and VRBO, I do notice at that intersection, sort of where my house is catty corner to, on the other side, more like downtown Waldo, there are a handful. But I have not seen any that are next or near, on the same block as this house.
Okay, thank you.
You're in the west side of Vernal, right, Ms. Kuhn?
The east side of Vernal.
The east side, okay.
I have a question for Ms. Kuhn. Did you approach the neighbor to the south and then they declined?
I appreciate that question. The house to the south is owned by the Housing Authority of KCMO, and I spent 3 months with snail mail, phone calls, emails, and have just been unable to get a reply, I think as a result of not being able to effectively navigate the system to find the right person. So that is why I am here, not because of a no, but because of a communication problem.
Understood. Thank you.
Board members, anything else? Motions?
I'd offer a motion.
Thank you, Ms. Mixdorf.
In case number 58, I move the applicant's request be granted in accordance with site plan, staff report, and the conditions therein, including the modification to 5 years.
I have a second to that.
Second.
Second from Mr. Stiller. Anna, please call the roll.
Lawrence,
Aye.
Moran,
Aye.
Mixdorf,
Aye.
Stiller,
Aye.
Tibbetts.
Aye. Your motion or your request to the BZA is approved. Good luck with your project, Ms. Kuhn.
Thank you for your time.
Sure. Moving on to the next case. That's docket number 5, case number 172 with an address of 8711 North Booth Avenue. Will the applicant please raise their hand, and also any people in the audience that would like to offer testimony in this case? We have the Casey's raising their hand.
We have username Dallas. They have raised their hand and have been promoted, and they are connected.
See anyone else, Anna?
No one else has raised their hand.
Anyone in the live audience wanting to offer testimony on this case? Seeing none? Let's see here. It's Casey.
Alice Truex is listed
Yeah.
as the applicant, though.
That's true, yeah. Mr. Truex, could you turn on your camera and microphone, please? I see Dallas down there. Assume that's your first name? you are. Could you raise your right hand to be sworn in, sir? Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
I do.
State your name for the court reporter, please.
Dallas Truex.
Thank you. Mr. Truex, there's a list of administrative exhibits labeled 1 to 9 found on page 3 of the staff report. Do you have any problem with us admitting those for your case today, sir?
No, sir.
Thank you. Those are admitted. In addition, a part of that exhibits is a presentation by Mr. Clements on your case. Jared, please tell us about this today.
Thank you, Mr. Chair. Give me one moment to share my screen. All right, before us, we have docket item number 5. This is case number BZA 2022-172, located at 8711 North Booth Avenue. The applicants in this case are seeking a setback variance to allow for a pool to be built in their rear yard. This is the location of the subject site from the Shoal Creek Valley area plan. More specifically, the property sits at the end of North Booth Avenue, which is a cul-de-sac. Their rear yard abuts a golf course. This is the proposed site plan brought forward by the applicant. You can see the proposed pool there to the north. It is 6.7 feet from the rear property line, has to be 10. Another rendering from the applicant. You can see some landscaping there and the pool in question. So the variance in question is for 3.3 feet. A substantial change to the character of the neighborhood is not anticipated. Difficulty could be obviated by a change in design. With that, I'll conclude my presentation.
Thank you. Mr. Truex, why should we grant your application today?
Basically, the homeowners are just wanting to be able to place a movable or a standalone spa on the back side of their pool there. The location of the fences will not change at all. And they're just wanting to place a standalone spa just on the far side of their pool.
Is the house built?
It is in the process of being built, yes.
Okay.
It is not concluded yet, no.
Can the pool be moved a little bit closer to eliminate the request for variance?
It is, we're at, right now, we're at 7 feet right now. So we're a little nervous about moving it very much closer to the house.
Board members, questions of the applicant?
I guess I might have a question. Oh, sorry. Maybe for Jared, that when I look at the site plan, so it says the 6.7 feet to the proposed pool, but this new plan shows this additional spa to the north. So has it already been shifted? And so
Yeah, we've already shifted it to the one that has the actual spa there is the one that's at the 5 feet. We've actually moved it a little closer already.
Okay, so then the 3.3 feet or whatever was noted is accurate.
Right.
Okay.
I originally, when we first did this pool, I originally had done a plan and had received the permit prior to that. The homeowners then decided that they wanted to do that, so we had to make some adjustments. And so, again, we initially had the permit, but then with the adjustments, I had to ask for the variance. And so the one with the spa in it, drawing in there, that's the one we're requesting.
So if anyone makes a motion for this, it actually should be for 5 feet, not as proposed in the.
Yeah, and that, yes, and correct.
It was not made clear to me.
Yes, not the actual pool. It's just the slab for the spa.
Okay.
Mr. Clemens, that's from the rear yard setback, correct?
That's correct.
Okay, thank you, sir.
I have a question for staff.
Okay, Mr. Stellar.
Do we have an affidavit on file? I didn't see one in the staff report.
We do. We typically keep those administratively. We don't attach it to the staff report.
But we're good there?
Good there.
Thank you.
Mr. Gorence?
You talked about a fence. I can't see how tall is the fence and is it locked or keeping people away from the pool?
Yeah, that's all standard for City of Kansas City. It's 4 foot and it's all locked and that sort of thing.
Okay, thank you.
Any other question, board members? Motions, anyone? And keep in mind, it needs to be for 5 feet, not 3.3.
Mr. Chair, in case number 172, I've moved that the board grant the variance as requested with a 5-foot setback, rear yard setback.
Yes, thank you, Mr. Stiller. Do I have a second to that?
Second.
Thank you, Ms. Mixdorf. Anna, please call the roll.
Torrance,
Aye.
Fran.
Aye.
Mixdorf.
Aye.
Stiller,
Aye.
Tibbetts.
Aye. Sir, your motion or your request has been granted. Good luck with the pool. Thank you very much.
Okay, thank you much. Thank you for your time. Appreciate it.
We're still good on time, so let's call the next case, docket number 6. With case number 202 with an address of 4515 North Olive Street. Will the applicant please raise their hand? It looks like Cody Hilbert. And anyone else who's interested in this case, please raise your hands as well. Oh, we got a live person here. A couple of them. Okay.
There's no one raising their hand online.
All right. Gentlemen, do we have Cody yet? Oh, you're live. Come on up. Sorry, I was looking for you on the TV. And please bring the other person who may want to offer testimony as well. We'll swear you both in. Please have a chair next to Mr. Clements. No, come on up, right here at the table. Have some candy if you want. Yeah, both of you. Yeah, there's room. Do we have a microphone?
Yep.
Okay,
There's a microphone there.
thank you. All right, will you please raise your right hands to be sworn? Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today? Please state your names for me and the court reporter.
Cody Hilbert, Shane Hollowell.
Thank you, Cody and Shane. Second here. Who's speaking on the case? Is it Mr. Hilbert? It is, okay. And kind of get close to the microphone so you'll be listed up there. Sir, on page 3 of the staff report, there are a list of administrative exhibits labeled 1 to 9 that we need in order to hear your case today. Do you have any problem with us admitting those?
No.
Okay, great. Those are admitted. Part of that is a presentation by Jared Clements to your left, and he will tell us about the case. Jared, thank you so much. Go ahead.
Sure thing. Thank you, Mr. Chair. So before us, we have docket item number 6, case number CDBZA 2022-202. The location is 4515 North Olive, zoning district R-6. Applicant in this case is seeking a variance to the residential parking area setback requirements. The necessity for this variance is stemming from a conversion of a garage into a livable area. When that occurs, the garage ceases being a place where you can park, and therefore the parking area setbacks are in place. So this is the location of the subject site, the Wynwood Briarcliff area plan. More specifically, it's on North Olive Street, as you can see on your screen. So this is the site plan submitted by the applicant. You can see the 35-foot setback requirement, and that's kind of a shorthand. It's really a 20-foot setback requirement, but we also require a 15-foot area for the car itself. So see those kind of interchangeably used. Regardless, it's 32 feet and 1 inch to the structure. So 2.9 foot variance is required. Substantial change to the character of the neighborhood is not anticipated, given that this structure is existing. Difficulty technically could be obviated by a change in design. With that, I will conclude my presentation.
All right. Anyone else in the audience who wants to offer testimony on this? Nope. Gentlemen, why should we grant your motion, your request today?
I hired a contractor to do the driveway because I was doing the stuff on the inside that I could do, but I'm obviously not a concrete guy. He failed to pull the permit. I had him design the driveway. Water was pooling up at the base of my house, so he kind of sloped it to where it would all shed away from the house, but he didn't pull the permit. Since he didn't pull the permit, it's kind of put me in this spot. I've been in.
Do you have any neighbor opposition to this? I don't see any online or any that was done here. So
No, sir.
you posted the sign, sometimes neighbors will come up and want to know what's going on.
Yes,
So,
sir.
Okay.
I've been to that property several times and neighbors literally walk by. Oh my God, I love what you did. I mean, this was a bad looking house.
Right.
Bought it for like $60,000.
Right.
It needed a lot of work and the neighbors literally walk by. I love what you're doing. Can't wait till it's finished. Like it's.
You intend to live there, Cody?
You go to that map at the very end. So I'm the GIS coordinator for the city of Blue Springs.
Oh.
So when Cody first came to me and it was like, well, we don't have that 35 foot. I was like, well, that's going off pretty old aerial photography. And your parcel data is kind of, so what I did is I took Mark, Mid-America Regional Council. They had a brand new aerial flight. That's what this aerial is from 2022 that shows the new driveway.
Right, I saw that.
And then I contacted Clay County and they sent me this parcel. So I could overlay it. So where you see that 35 foot mark, that's actually where the edge of the house is, not where that red line is. That's the overhang or the angle of the satellite coming down. So the actual concrete, is the edge of the house to that line measures exactly 35 feet. That's kind of why I was like, I don't even really see the need for a variance because it does kind of meet your setbacks. So, I mean, we're kind of debating over, maybe it is 34 foot, maybe it's 30. At the end of the day, water was getting in the house or pooling up against it. Had a guy come out and make it look 1,000 times better. And fortunately, the contractor failed to pull the permit and we didn't know that
right.
This was going to be what it ended up being.
Would you like staff comment on that or is there?
Sure, go ahead.
Our orthographic photo data is also from 2022. We can compare the accuracy of both orthographic photo sets, but I think we're here and can make a determination and get this through permits.
Right.
If we make a decision today, so.
And I would kind of agree with that, Mr. Clemens, in that two things. One, the accuracy of this type of images, in personal experience, I've seen anywhere from within a foot to off by as much as 6 feet. So given they don't have a survey, we don't really know where this is to, with the assumption that 2 feet 11 inches probably gets them where they need to be. And I also just wanted to ask real quickly, we do we not measure from the property line to the face of the structure as opposed to overhang, or is it overhang?
I believe we go to the face of the structure.
So that would just give them that much more flexibility, given the margin of error with these aerial images. Okay, thank you.
Any other questions, board members? Or motions?
I'd offer a motion.
Well, thank you, Ms. Mixdorf.
Case number 202, I move the applicant's request be granted in accordance with site plan and staff report.
I have a motion. Do I have a second for anyone?
Second.
Thank you, Mr. Stiller. Anna, please call the roll.
Lawrence.
Aye.
Fran.
Aye.
Mixdorf.
Aye.
Stiller.
Aye.
Tippett.
Aye. Your request has been granted. Luckily, you don't have to tear out your concrete.
Thank you.
Okay, thank you. Sure, thank you.
You too.
I think we have time for one more case. We're going to call docket number 7, case number 205 with an address of 402 West 59th Street. Will the applicant please come forward? Mr. Cook. Anyone in the virtual audience have interest in this case, please raise your hand. Have a seat, Mr. Cook. Seeing anything, Donna?
No one has raised their hand on Zoom.
Thank you. Let me get to the page there, sir. It'll just be a second. I'm almost there. There we are. Sir, I'm going to swear you in. Please raise your right hand. Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
I do.
Thank you. State your name for the court reporter, sir.
Orjan Cook.
Thank you. Mr. Cook, in your staff report, there is a list of administrative exhibits labeled 1 to 9 found on page 3 of the staff report. Do you have a problem with us admitting those for your case today?
Oh, that's fine.
Thank you. Those are admitted. Mr. Clemens, part of those is your presentation, so please present your case. Thank you so much, sir.
Mr. Chair, before us, we have docket item number 7, case number CDBZA 2022-205. Zoning district is R6. The applicant in this case is seeking a variance to the accessory structure siding requirements to allow for a garage to be built in the street side yard. So the code prohibits accessory structure in the street side yard, and this accessory structure is proposed in the street side yard. So here is the location of the subject site. It's within the Country Club Plaza area plan. More specifically, it's on the corner of West 59th Street and Warnell Road. See the site plan here for the proposed project. You can see the home there, kind of in the middle of the property. So the entire area between the home and Warnell Road is considered the street side yard. And the entire area between the home and 9th Street is considered the front yard, leaving these two areas as the remaining potential areas for this garage. So the variance is a complete deviation. A substantial change to the character of the neighborhood is not anticipated. The difficulty could be obviated by a change in design. With that, I'll conclude my presentation.
Thank you, Mr. Clemens. Mr. Cook, why should we grant your request today, sir?
Well, it's our desire to get our cars off the street for one thing. And secondly, we currently have a 1-car basement garage, and the sight lines are pretty limited coming out of the basement, and probably safer garage that we have proposed.
The cut on Warnell Road, isn't it? Yeah. Crazy street to back into, or
pardon me?
It's a crazy street to back into.
Yeah, it is a little tough.
Board members, do you have any comments or questions for Mr. Cook?
Mr. Cook, along with this, are you intending to remove the existing concrete drive or leave it?
We'll leave the existing drive.
Say it again, Mr. Cook. I did.
We'll leave the existing drive.
You'll continue to use the
pardon me?
Below grade, the under the house garage for vehicle storage?
Mainly storage, yes.
But you won't, no vehicles parked down there any longer?
No, we can't get either one of our cars in that garage.
Too small. Yep, and I'm assuming by what you're talking about, the sidelines, that concrete drive is pretty much, somewhat below grade until you get right out there at the street line.
Pardon me?
Again, Mr. Stellar, he didn't hear.
Oh, I take it the existing concrete drive is below ground or below grade from the house almost all the way up till you get out to the street line.
Yes, it is almost.
Okay, thank you.
Will you have enough room on that concrete pad to turn your car around to go out forward?
We actually have a concrete pad poured next to the sidewalk, and
For safety reasons.
Existing drive.
That's the first image that's attached here to the staff report then, right? Showing that single car on that pad.
See.
You have any comments from your neighbors about this garage?
No, none whatsoever.
I drive that area a lot. I just don't recall seeing that pad over there. Looks.
For me?
I drive that area a lot. I just don't recall seeing that pad over there.
We just moved in the house about a year and a half ago and we put it in about that time. Yeah, it's not real obvious. Yeah, hope to incorporate it in the existing drive. So the actual curb cuts won't be as wide as drive.
Right.
Is the building going to match the, your house? The outside of the building going to match your house? Color and everything?
As close as it can. It's a gray stucco and have a hip roof. House has got slate roof and we're not going to put slate.
Yeah,
on
no,
it.
I understand.
Okay. Board members, any other questions or motion?
I'd offer a motion.
Sure. Thank you, Ms. Mixdorf.
Case number 205. I move the applicant's request be granted in accordance with site plan and staff report.
I have a motion. Do I have a second from anyone?
Second.
Thank you, Mr. Gorns. Anna, please call the roll.
Lawrence,
Aye.
Moran,
Aye.
Mixdorf,
Aye.
Stiller,
Aye.
Ebbets.
Aye. Mr. Cook, your project is approved. Good luck with it. Thank you, sir.
Thank you for, thank you. And thank you for your time.
No, thank you.
You.
It's near our lunch break, so everyone take about 30 minutes. We'll meet back here at 12:30 if that's acceptable. Perfect. Thank you.
There's many tabs open.
Sorry. Then I sent a note over to Stiller, said wave. Okay, think we're ready?
Amber back.
Amber, are you back? Ms. Crosby? Yes, no, there she is. Hello, Amber. Okay.
Hi there.
Hi there. Thank you. The afternoon session is beginning. Our next case on the docket is case number 9. Case number 2023-02 with an address of 15 East 15th Street. Will the applicant please step forward or raise their hand? We sit live.
55th Street.
Mr. Byers, have a seat. Take a second to get to your case, but it'll just be a second.
Page 55.
Okay.
6 technically. Exhibits.
The exhibits are, okay. All right, sir, will you please raise, anyone in the audience who's interested in this case, either live or virtual, please raise your hand. Manana?
No one is raising their hand on Zoom.
Mr. Byers, will you please raise your hand to be sworn? Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
I do.
Thank you. Please state your name for the court reporter.
Andrew Byers.
Thank you. Mr. Byers, on page 3 of your staff report are a list of administrative exhibits labeled 1 to 9 that we need to admit for your case today. Do you have any problem with us doing that?
No objections.
Perfect. Those are admitted. Part of that is a presentation by Mr. Clemens on your left. Jared, please tell us about the case today.
Sure thing. Thank you, Mr. Chair. Before us, we have docket item number 9, case number CDBZA 2023-0002, located at 15 East 55th Street, zoning district R75. The applicant in this case is seeking a variance of the accessory structure separation requirements to allow for a carport to be constructed basically within 10 feet of his principal structure. This is the location of the subject site, 5th Street. More specifically, it's 55th Street, just east of Main Street. You can see the property there. Here is the site plan provided by the applicant. You can see that the pergola structure is some 4 feet from the principal structure, which is 6 feet closer than what is allowed by code. Rendering of what the applicant is proposing. I believe part of the proposal is to someday include solar panels on top of the pergola structure. Variance is for 6 feet. Substantial change to the character of the neighborhood is not anticipated. They could be obviated by a change in design. That'll conclude my presentation.
Okay, thank you. Mr. Byers, why should we approve your case today, sir?
Thank you for the time. Yes, the proposed pergola is to park 2 cars side by side. And so to provide enough room and also for the structure of the pergola, that'd be about 20 feet wide. Currently, maybe you could pull up the site plan.
I see that.
There's a driveway already existing. My house actually sits a little bit, not in the center, but off to the east. And so there is this area here that I could put the pergola in, the carport and park 2 vehicles under there. Currently, I will admit to having 5 vehicles, 3 that I use normally and 2 that I'm restoring. And so I'd like to have room to have all that off the street. It's very difficult to park on 55th Street. It's a fairly busy street.
Right.
I will, in all transparency, as Jared mentioned, I actually started this concept as part of a Solarize KC initiative, looking at adding solar panels to different residences, and it's sponsored by both the city and Evergy, the utility company. This location was, I could put, it was originally thought to be a ground mounted solar energy structure. And I chose this location because if I put the solar panels there, it would account for the track of the sun, but also in the winter for my surrounding neighbors' trees to keep them from being too much of an obstruction to that.
I see.
Was to account for the other neighbors' trees. So I also come before you requesting that I had requested particularly this 4-foot separation as opposed to this 10-foot separation, so that would fit in between here. Admittedly, there's a little uncertainty from from having talked to 2 different planners as to how a carport is considered. I know that there's a garage and carport mentioned in the ordinances. So I'm asking for the separation, which I absolutely need, but if there are other approvals, particularly with regard to height and footprint, I'm asking those to be incorporated as well. Again, if it was considered a garage, it would be completely within the ordinance. A carport is not really called out that I can tell in the ordinances. So I'm asking for those considerations as well.
So you access the driveway off 55th Street.
That is correct.
Are you the first house from Maine to the?
No, I'm the 3rd house east of Maine. Kind of know where Westover Road swings off. I'm just almost right in front of where that splits out.
Right. Okay. Any neighborhood opposition, Mr. Myers, from this?
No, I actually personally sat down and met with my neighbors behind me on the east and the west and across the street and showed them the pictures. I also reached out to our homeowners association and provided them with all the information that's in the file, and they, to my knowledge, had no objections. So.
Sometimes this board doesn't like carports, but yours is not really a carport per se. It's more how to say it, but it's not exactly a carport.
Well, it may have multiple uses if I do add the solar panels in the future, but I'm only here for this carport pergola.
Right, the pergola part. Yes, I understand that. Great.
And we did make an effort to design the pergola, and there is a picture there in the application that
we see
hopefully matches a lot of the architectural features of the house as well. The pergola probably would be brown instead of white. I just had that rendering made electronically to make it easier to see.
Okay. Keep trying to place your home one more time, but you're the other side of the street than St. Teresa is.
Yes.
Right? Yeah. All right, board members, do you have any questions? Mr. Myers? Motions, anyone? Mr. Stiller, you awake?
I'd offer a motion.
Yes, I am.
In
No questions.
in case number 2, I move the applicant's request to be granted plan and staff report.
I have a motion. Do I have a second?
Second.
Thank you, Mr. Stiller. Anna.
Lawrence. Moran.
Aye.
Rixdorf.
Aye.
Stiller.
Aye.
Ebbets.
Aye. Your project is approved, sir. Good luck with it. Thank you.
Thank you for your time.
No, thank you. As I'm driving down towards XY, I'll look for it in the next couple months.
Good. Enjoy your Valentine's Day.
Thank you. All right, we're now on docket number 10, case number 206 with an address of 810 Glebe Terrace. Would the applicant please raise their hand? Mr. Shaw? Craig? And anyone else who's interested in this case?
The
I see.
applicant has been promoted. And then there is a Casey who has raised their hand.
Okay,
You must accept the promotion, Casey, if you wish to provide public testimony on docket item number 10. Craig and Casey have been connected.
I see those. All right, I recognize Mr. Shaw. Will you guys raise your right hands to be sworn?
And you both are muted, by the way.
Yeah.
There we go.
There we go. Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
I do. Say Christian. That is Christian. I'm Scott Tillema, architect also. I do.
Okay,
I'm Casey Ventrilo. I'm a neighbor. I do.
great. Thank you. Who's speaking? Mr. Shaw, are you speaking on behalf of the case today?
I will.
Great.
I believe that this is a really simple case. We have an existing. We have an existing garage that we're. adding-
Wait, hold on.
Yep.
We've got to do some paperwork first.
Okay.
So who's ever speaking on the case, we have a list of administrative exhibits labeled 1 to 9 located on page 4 of your staff report. Do you have any issues with us admitting those for your case today?
No.
Great, those are admitted. One of those is a presentation by Jared Clemens about your case, and he'll go ahead and talk about it.
Thank you, Mr. Chair. So before us, we have docket item number 10, case number CDBZA 2022-206. Location is 810 Glebe Terrace. The applicant in this case is seeking approval of a variance to rear yard setback requirements for a garage addition. And while getting that variance, they're also seeking 2 side setback variances on the existing structure. This is the location of the subject site. More specifically, it's on Glebe Terrace between Charlotte Street and Campbell Street near Zion School, if you're familiar with the area at the north end of Gillum Park. This is the site plan provided by the applicants. You can see the existing garage on the north of the structure and how they're expanding that into the rear yard setback. And then on the sides here, you can see proximity between the principal structure and the side yard setback is pretty narrow. So those are the variances being sought as well. So for the first variance, variance A, it's the north structure for 7.33 feet. Substantial change to the character of the neighborhood is not anticipated. The difficulty could not be obviated by some feasible method other than a variance. The next one is the east side, existing side setback. It's for 3.66 feet. Substantial change is also not anticipated. It could not be obviated by some feasible method. The next one is for 6.75 feet on the west side of the structure. Substantial change is also not anticipated, and the difficulty could not be obviated by some feasible method other than a variance. With that, I will conclude my presentation.
Great, thank you, Mr. Clemens. Mr. Shaw, why don't you tell us why we should approve your case today, sir?
It's a fairly simple case. The anticipated project is an addition to the garage, 2 feet to the garage to the north and 2 feet addition to an existing garage footprint to the east. And then we were putting a second floor on the garage. The garage has always been attached to the house, so it's not a detached garage circumstance. Let me take this thing off. And the rest of it is, project is existing. The house is where it is, and we're asking to leave it there. So I think it's a fairly simple addition. Materials and stuff are consistent with the rest of the house. It's a beautiful historic house. And we're not doing anything that affects the street presence or our neighbors to the east or west. And the 2-foot addition to two sides of the garage seems a minimal effort to give them the ability to get into the garage better than they can right now because of the tight turn on the driveway. So we think it's a fairly simple case. We're looking forward to the approval and getting the thing constructed.
Okay, thank you, Mr. Shaw. Mr. Shaw, did you have any neighborhood opposition to this so far?
None to my knowledge.
Okay. And that's in Hyde Park, sir, or is that outside of Hyde Park?
It is in Hyde Park, in central Hyde Park.
Right.
Right on.
I've never
right
heard
on
of
the park.
Glebe Street before. All right.
Sorry, we're having a little technical problems here.
Mr. Ventrello, did you have some testimony you want to provide today?
I just wanted to ask the committee to approve the project. I'm the neighbor directly to the east next door to the property, and we think the garage will be a great addition and minor change to the house, and we're excited about it. We just wanted you to know that me and the other neighbors that surround them are all in support of the proposed project.
Thank you for your testimony today, sir. Board members, any other questions for the applicant?
I actually have a question. The owner, you said you're going to put an upstairs, a second floor to it?
Yes, sir. That's the proposed project.
Someone going to be living up there?
Just a family room space.
It is attached to the house.
It's all attached to the house. It's just an extension of living space. It's not for somebody else. It is an extension of the existing house.
That's you. Thank you.
Good. Well. Perfect. Speak out.
In case number 206, I move the applicant's request be granted in accordance with site plan and staff report.
I have a motion. Do I have a second?
Second.
Second, Mr. Gorens. Anna?
Lawrence, Moran,
Aye. Start.
Extorf,
Aye.
Stiller,
Aye.
Ebbets.
Aye. Mr. Shaw, and your project is approved. Thank you.
Thank you for your consideration.
Don't go away. You're next.
Oh, I'm back again.
All right, thank you.
Mhm.
We're going to call the next case, which is BZA 2023, case number 3, with an address of 709 West 50th Street. Will the applicant please raise their hand, which is Mr. Shaw, and anyone else in the audience who'd like to offer testimony on this case?
Jacob, you have raised your hand and I've sent a promotion. They are connected.
Okay. It's like Mr. Hodge is the owner.
No, Hodges Builder.
Oh.
No, we're both Hodges, but I'm the owner.
Okay, give me a second here.
Okay, yes, that's correct.
Right. Who's speaking on the case today, by the way? Mr. Shaw?
I will at least open the conversation.
Okay, so I'd like to, each of the people offering testimony today, I'd like for you to raise your hands. Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
This is Jacob Hodge, I do.
Thank you.
Craig Shaw, I do.
Thank you, Craig.
And also maybe Scott.
If I'll raise it when I come in.
Okay.
Okay. Gentlemen, like in the previous case, you have administrative exhibits labeled 1 to 9 found on page 3 of the staff report. Do you have any problem with us admitting those for you? Oops, I'm on the wrong. No, I'm not.
I think so.
Do you have any problem with us admitting those today, sir?
Say no.
No.
Okay, thank you. Part of that is a presentation by Mr. Clements on your case. Jared, please tell us about it today.
Sure thing. So before us, we have docket item number 11, case number 3, located at 709 West 50th Street, zoning district R6. Applicant in this case is seeking approval of a variance to the accessory structure separation requirements and the accessory structure height limitations to allow for a garage to be constructed west of the existing principal structure. This is the location of the subject site. More specifically, it's just at the corner of West 50th Street and Summit Street. So you're gonna have to kind of turn your head, but the orientation of the lot made better to be turned sideways. So north is actually to the left. Specifically, there is a separation of 7 feet between the two structures. This case, see the height, it's 29 feet to the top of the roof beam. I have to look to your staff report. I don't have the number memorized of how that height calculation goes based on our code. So variance A, the separation is for 3 feet. Substantial change to the character of the neighborhood is not anticipated. The difficulty will be obviated by a change in design. Variance, the second variance, variance B, is for 8 feet. Substantial change to the character of the neighborhood is also not anticipated, and the difficulty could be obviated by a change in design. With that, I'll conclude my presentation.
Thank you, sir. It's quite a bit of height variance. Why should we grant your motion or your request today, sir?
The whole reason for us approaching you with this variance is because there is a sewer line undocumented by the city that is running right next to the existing house. The initial design had this garage attached to the building, to the existing house. It was permitted, construction started, and in the course of construction, a sewer line running from someplace south towards the north was discovered, and forcing us not to be able to build the addition where it was originally conceived. So what we have offered here is to move the garage a few feet away from the existing house to allow the sewer line to remain in place. Again, undocumented sewer line, undocumented city sewer line, so we could still accomplish what was originally permitted. So it's a simple matter of the city and not knowing where their sewer was that has forced us to ask for this variance to begin with. Again, we were originally permitted with this addition attached directly to the house. Construction started, and that's when the sewer line was discovered, which causes us to be in front of you now. So we're asking for the variances to allow what was already permitted to happen just a few feet to the west of where it was originally conceived.
Thank you, sir.
I would defer to the homeowner for additional comments because they're the ones that have suffered through the hole in the ground for many months without being able to do anything with it.
Yeah, if you're okay with that, I'd like to add a few things.
Yes, go ahead.
Go ahead.
So yeah, we've been living in this circumstance for the better part of a year now. We've worked with the city and the city sewer department very closely after we discovered the sewer line, stopped construction, but we did rip up 75% of our driveway. We have the foundation built. We ripped up our patio, and as you can imagine, that's created a lot of complications. Our neighbors have been incredibly patient. We did sit down with each neighbor before we came to this variance hearing, just to make sure everybody knew exactly where we were at, the changes that we were making to the original designs. Everybody is in very much support. They think the architectural plan is in complete support of the neighborhood in terms of homeowner value, community value. Our neighbors to the west, where the building would be the closest to, really want the variance to happen, because if it doesn't, we have to move the setback closer to the fence line. So they would actually prefer to be closer to our property. The new designs keep it outside the setback requirement of the sewer line and the residential sewer line that we found on the property where we first discovered it. So when we first bought this house, we knew that we were gonna have to develop to make this house work for us. And my wife and I have 3 kids. We plan on raising them here. And we had to give up 2 substantial pieces to what was originally going to be attached that we were going to make the sacrifice on. And this new design that we came up with Craig and our developer, who I really appreciate the time and energy they put into it, would allow us to stay here and make this property work for us long term. So my wife and I, as you can imagine, being in this for a year, I was very nervous about this hearing. I'm very hopeful, and so is my wife, that you allow us to move forward. The entire community is behind us. All the neighbors are in complete support of what we're trying to build.
Thank you. Is there going to be any connection, let's say an upper floor connection to this add-on to the accessory structure?
Yeah, there is an upper floor. That's actually one of the things that we need most out of this. That's why the height is higher, but it also just looks better for the quality of the neighborhood. So we need an extra space for our children. We don't have enough bedrooms, and my wife and I work from home part-time. So we're a hybrid working environment. So I'll have an office space above and a finished space, and it has a stairwell in the back of the building.
Let me answer that question. I like to speak on that part.
Yes.
Scott Tolma again. We would love to have the connection between the house, but again, the sewer line, we're not able to build over the sewer line. Even 20 feet above, 30 feet, 40 feet above the sewer line.
It's 30 feet above, yeah.
Right. Whatever, they're not allowed. We even tried to do a little trellis to help connect the 2 houses. Just 2x4 with trellis. That was not allowed. So we would love to have connection, but we're not able to due to the super.
And the only other thing I'll add into this is the city sewer department is in full support too. They were actually in full support of the trellis that we proposed. They actually went ahead and lined the sewer. The sewer line's 100 years old. They lined it, said the liner will last another 100 years. So they were in full support. It's 30 feet below where we were going to put the trellis. But that aside, we understand that they actually reached out to BZA, and BZA asked us to go through the formal process. So I'm completely respect of that. But the city sewer department have been very helpful through the process, even though it's been time consuming for all of us.
Thank you, Jacob and Scott, for your testimony.
I have
Anyone
a
else?
question for Jared. If this, I guess maybe it's for the applicant and Jared, are the foundations already poured for the structure in the place that it's showing on the plan?
No, they're dug out close. It's about, like Craig was saying, we have to move it about a foot back from the original foundation dugout. So we put the framing in where you pour the concrete, but we never poured the concrete. We found the sewer line before we got that far. And then we have to move it over about another foot. So it doesn't change. That's actually what we tried to do, because otherwise we have to redesign. It will cost a lot more money and time and delays. But it's about a foot or 2 movement here and there to meet what you have in front of you.
Well, I guess my question is, if that's not already poured, is there a reason this isn't moved 5 feet, 10 feet further back that would alleviate the 7-foot distance between the structures? Because it looks like you have space further in the property.
There's several reasons. First is that if we move it 10 feet back, I have to pour that much. We had a driveway that went all the way up to where this building was going to be entered into, and the rest was ground. So we would have to then create a concrete driveway that goes back, and we're building a brand new concrete driveway. So our cost goes up exponentially with that. But the further we push the building back, it actually starts to interfere with the line of sight of one of our other neighbors. So we reviewed the plans with them. They're very comfortable where the footprint is now. But if we go further back another 10 feet, you start to interfere with their back patio viewing.
Well, would it
It's
even
also a grade change as we move further back because we go uphill. So construction gets much more difficult because the grade is higher the further south we go.
I was just thinking from Jared, is it a diagonal distance? Would it be 10 feet from the corner of the house? So maybe it's only 3 feet further back, or, something like that. It's not a full 10 feet to meet those separation requirements, or what does that look like?
Yeah, how you've interpreted it is correct.
Okay. So I guess my other second question on this, I know accessory dwelling units are now allowed in our ordinances. And I thought maybe I misinterpreted that I know this is not proposed as an accessory dwelling unit, but there's plumbing inside of it. So the potential for it to be there in the future, I think is possible. And is that they need to be behind the house? Is that one of the requirements of that ordinance?
I am
or
not
something,
sure. I didn't
or-
review it against the ADU
Okay.
standards.
I'm not sure I followed that. I mean,
That's a question for Jared. It's okay.
Okay, sorry, I apologize. I was gonna say the plumbing is behind the house, but I don't know if that's what you're asking.
Do we want to talk about the kitchen doors right there? Some kitchen doors, right?
I guess, is there any opportunity? It's just very, very tall. It is, looking at the elevations, it's the exact same height as your house.
That's exactly right. It was designed that way. If you look at the neighborhood, there's been a lot of variances in the neighborhood for similar reasons, and it's to keep that design actually supports the better. Overall, we reduced it and we looked at that from an architectural design to stay with the integrity of the neighborhood. The president of the HOA lives right 2 houses that way. Everybody's aware of what we're trying to accomplish with that. And again, it overall fits the look and feel of the neighborhood better. And we are having to spend a little bit more money to accomplish that height requirement, but it does add to the value of the neighborhood.
Yeah, and I guess I'm not dismissing that. I just, for an accessory structure, I have an issue personally with it being at the same height of the house. It just looks like it is an additional house on the lot, just looking at the elevations. So I didn't know if there was any potential. I mean, it looks like you're trying to match maybe the slope of the roof line, but if there's any other potential in terms of the rafter system that was selected or anything that could reduce that height. But I'm just one board member.
The design was meant to be consistent with the existing house. The roof pitches, et cetera, were meant to align themselves with the existing house so that they fit together.
Which I understand, but it looks like there's another roof pitch and maybe a part of the house that's further out. If it were to align potentially with that, it would still fit the character of the neighborhood, but not require the same height variance.
I guess I beg to differ. I think what we have drawn looks right with the house and is consistent with the neighborhood.
Yeah, because that other roof pitch isn't visible from the front lot. It's only visible to us in the backyard. It would look strange from a street view. The way the property goes up, it slopes up.
Yeah, I'm just stating my concern. I personally think it is too tall, but I'm open to other board members' thoughts.
Would it be helpful if I pulled up Google Street View?
Well, that's what I'm looking at right now. I see there's a smaller roof in front of it. That's what I was kind of referencing, but
That's just a little dining room.
and it's on elevation.
I'd like to
as
see
well.
that, Mr. Clemens, the street view. Thanks.
Absolutely. 1 second.
I guess my bigger concern, just for your awareness, stems from as we start looking at accessory dwelling units in Kansas City, and more of those are likely going to happen. I'm concerned about having additional units that look the same size as a house on the lot. And so that's just where my hesitation comes from.
But this is not an accessory dwelling unit.
Correct, but it's got all the things there that would be a good precedent for somebody else that would be pursuing an accessory dwelling unit in terms of height or garage underneath, things of that nature.
This is a garage with office space above to accommodate the owners working from home.
Thank you. I know, I understand.
It would have been attached, it's already been permitted with that height.
And it was already permitted at that height. It's just because of the existing sewer that was undocumented, we would just simply have to detach it and move it slightly, but it was already permitted as drawn.
At that time, it was attached.
Right,
So
yeah, and
it's the same
attached structures have a different stipulation,
Right.
correct?
Yes.
And I guess my other concern, and I will stop talking, is just when we look at that 7-foot difference for such a tall structure, it just is kind of a canyon between the houses. When we look at a single story garage and it's only 7 feet, I have less of an issue because it is a smaller structure. With this height and that distance, I'm just a little concerned.
Yeah, the driveway slopes up, I think, I don't know, I can't remember exactly, Craig, too. So when you're at street view, we have a tree.
Jared actually has it up on
Okay.
up on
I can't see.
screen. He's got Google. Do you want to share your screen too? Maybe. Sure. Perfect.
Yeah, so that where that tree and those bushes are, that's actually where the attachment would originally happen back at the end of the property. So when you're at street view, what you'll see is the same roof pitch in the building, but you're not going to see the gap.
The neighbor to the right has no concerns with you. That'd be the one in the kind of white house with the red roof.
That was actually the one I said that would actually prefer the variance. Otherwise, we have to move closer to his property, and he loves the design that we've come up with. Yeah, they're both in full support of what we're doing. We've actually talked to every neighbor that you can almost see on this street, including another one that's next to that one with the red roof on that other street on Summit.
Mr. Chair, just a housekeeping issue. I would suggest that we admit as Exhibit 10 what Jared is sharing on his screen, which is a Google view of the property.
So the Google Street View exhibit is now Exhibit 10 and will be admitted for this case. Thank you.
I know that you're considering, and I know you're considering for the future. I'll just say one thing. Again, I'm just pleading for this, obviously. When we first moved in, we had to make significant investments into this before we ever knew about the sewer line. There was a tree that we knew was dying. It was above the house. We had to remove it, but it was a massive tree and it cost a lot of money. There were other investments that we've had to make in the property. We've been living with a gravel mud pit off of our patio. We had to put security fencing up. Our insurance company came out and has made mandates for us to maintain our insurance is all part of the delays. It took 2 months for the city to find the records that they even owned the sewer line. They first thought we owned the sewer line, and then it determined after looking at 3 storage units that they owned it. And again, we were patient with them, working with them. We're trying to move forward without having to re-architect the whole design, get the things that my family and I feel like we want out of this and need out of this to maintain and stay in this property, but also have a look and feel design of something that we can live with and see every day and live here long term. And there's no one in the neighborhood who opposes it. Everyone is in full support. And I would ask for an approval to move forward with this. We've been living this way for a year, and we've gone through every step patiently, never aggressively with the city, always cooperatively. We grew up in Kansas City. We want to raise our kids here. We love the culture of Kansas City and where we're located at. And I'll just ask for the approval again to move forward.
Small housekeeping item, Mr. Hodge. Is that the house kind of across the street, the grayish one? Is that the Pastilli old home?
Can you pull it back up? Are you talking about, let's see, that'd be west. Are you talking about north?
I think it's a little bit north.
That's the one also. They just went through a variance process for a building structure they built. Is it white?
I'm going, Jared. The other direction. Keep on, you see it. Keep on one more.
What you
No,
guys are
you're going
seeing-
there, right there, that one.
what you're seeing on your screen, I'm not seeing.
Oh, you got to
Share my screen again.
Hold on.
Share the screen, please.
Just trying to place that location.
Sure. Oh, yeah. Yeah. So this house is now white, and they were the last ones who went through a variance in the neighborhood. They built a big structure in the back that was didn't meet setbacks requirements too. But I don't know who previously owned that. Actually,
No, that's the one I'm thinking of. So that's fine.
I know the Pastilli home is south and about a half block west of our location.
Okay. Thank you. That's fine. Good. Board members, what's your thoughts?
I don't think I've ever seen a more textbook clear case of a hardship than this.
I agree. That's what I was going to say. Aesthetically, I agree with Ms. Mixdorf's comments, but I think because of this clear hardship and because of what the applicant's been through and because of the agreement of the entire neighborhood, I would.
And it was approved before they had to separate it. So they're here because of the separation. So yeah. All right. Anybody with motion?
Yes, and enough of the gauntlet.
Sorry. Oh, sorry, Tom.
I would offer a motion.
Thank you, Mr. Stiller. Go ahead.
Case number 11, case number 11, case number 3, I move that the board approve the applicant's requests in accordance with staff report, site plan.
And staff report. Great.
Second.
Second from Ms. Moran.
Thank you. I appreciate it.
Call the roll.
Lawrence.
Aye.
Moran.
Aye.
Rixdorf.
Opposed?
Stiller.
Aye.
Ebbets.
Aye, yes. Your project is approved. Good luck, Mr. Hodge.
Thank you.
Shaw.
Thank you. Valentine's Day. Enjoy the rest of your day.
Apple from Moran.
Oh, man.
All right. Case number 12 was continued. Let's jump to case number 13. Docket number 13, case number 5 on the address of 5909 Northwest 78th Terrace. Will the applicant please come forward? And anyone who's online who's interested in this docket number 13, case number 5, please raise your hand to be promoted.
No one has raised their hand on Zoom.
Take me a second to get to where everyone is. Post.
It's like it's page 8.
You. Okay. I'm assuming you're Matthew Har.
I am representing Matthew Har, Daniel
Okay.
Thompson.
Will you please raise your right hand to be sworn? Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
I do.
And what's your, state your name for the court reporter?
Daniel H. Thompson.
Thank you, Mr. Thompson. Let's see here. Sir, on page number 3, there are a list of administrative exhibits labeled 1 to 9. Do you have a problem with us admitting those for your case today?
I do not have a problem with it.
Thank you. Those are admitted. Part of that is a presentation by Mr. Clements on your left, who will talk about the case. Jared, go ahead.
Chairman Ebbets. So before us, we have docket item number 13, case number CDBZA 2023, number 5. 5909 Northwest 78th Terrace is the location. Zoning district R-6. Applicant in this case is seeking approval of a variance to the rear yard setback requirements to allow for an enclosed porch addition to be completed on the existing home. So this is the location of the subject site. More specifically, it's on Northwest 78th Terrace between North Dalton Court and North Revere Court. You can see the property there abuts a pond or detention lake, something like that. So here you can see the site plan submitted by the applicant with 16 feet between it and the rear yard. By our permits department's interpretation, when a porch is enclosed, it's an addition. And so this is technically an addition to the home and therefore is subject to the regular rear yard setback requirements. As such, the variance being sought is for 13.93 feet. Substantial change to the character of the neighborhood is not anticipated. The difficulty could be obviated by a change in design. With that, I'll conclude my presentation.
Okay, perfect. Mr. Thompson, why should we approve your case today, sir?
Well, when we started the process, they had just moved in. They were under the understanding that their property line went to the back. That is not the issue. That's why we are even here today, because we kind of went down that road without me making the mistake of not confirming it before I fully discuss it. I would avoid this situation at all costs, but looking at their situation, there's with the setback rules, you would only, the setback goes to 30 feet. Their house sits 32 feet from the property line. They would not ever be able to add anything to the back of their house without some sort of variance as far as a roof and enclosure goes. I spoke with the homeowner about, hey, what are our options for not having it screened, things like that. But even if we do have it unscreened, we do have to have a variance as far as within that 20 feet from the back property line if we go out 16 feet. I also investigated other spots on the house to do the addition. There's just no real place to put it. In all cases, when I get into this situation, I try and avoid this. So, hey, let's put it on this side of the house or that side of the house. In this situation, it's fairly unique. If we're going to have a variance in the first place, we might as well try and get the variance that solves all the problems of the homeowner. We are available for whatever. We're kind of at your mercy. So obviously we will do what it takes. But at this point, we're kind of down the road. We've had blueprints drawn. We've had monies exchanged, things like that. And we'd like to be able to build this. It does not obstruct any view from any of the neighbors. None of the the homeowner has spoken to all of the neighbors. They have a beautiful view of their pond/lake. Lakes have mosquitoes, so screening it is valuable for them.
Thank you, sir. What about some neighbor opposition or support?
Not at all, not that I'm aware of. I would imagine there are other people with the screened-in porches. I would assume would support it, or they would have come forth and said, we are opposed to that. But again, going to all the property lines, most all of them, except for on that side, go to the lake. But again, this site, the property lines are fairly small.
So you're coming off the rear of the home, should I say, about 14 feet? No.
Ideally, 16 feet would be is what we discussed when we initially met. They have an existing deck there now that comes out 14 feet. It's in disarray. It needs to be replaced. So they are redoing their kitchen. They just put in sliding doors there. That right now they have a metal thing, screened in area, roof area that is attached to the deck, which I think is a safety issue as far as if there was a microburst or strong wind, it could blow it off the deck, damage the deck, create a problem. This way we add value to the home, we add value to the neighborhood.
Board members, any questions? Go ahead, Mr. Gorens.
Let's say first floor deck.
Second floor.
Second floor. So what's gonna,
Yes, I'll have beams. We do 6x6, #1 grade, pressure treated timbers.
or more?
We're going to have 3 across the front and 1 on each side. And then they're going to have a double landing coming stairs off of that. And then and also a deck that will have access to through another doorway, which would be where they grill and things like that.
And the homeowners association, it looks like they were okay with it. I can't
Yes,
tell.
they is with approval with the proper permits, they will approve it.
I see. Yeah.
Yes.
Anyone else? Mr. Stiller, any other comments?
No comments, no questions, ready to go.
Make a motion?
Sure, if nobody else is any other questions?
I didn't hear any more, so.
Okay, docket number 13, case number 5, I move that the board grant the requested variances in accordance with staff report and site plan.
Second.
I have a motion for Mr. Stiller, a second, Mr. Gorens. Anna, please call the roll.
Lawrence.
Aye.
Moran.
Aye.
McStorff,
Aye.
Stiller,
Aye.
Tibbetts.
Aye. Sir, your project is approved. Good luck with it.
Thank you so much.
Sure.
Appreciate it very much. Thank you all for your
Thank you,
time.
Mr. Thompson.
Taking the touch break.
And as we approach towards the end of our docket today, we've got a couple more cases. We're we're calling docket number 14 with an address of docket number 14, case number 9, docket or address number 2131 Bellevue Avenue. Will the applicant please raise their hand?
The
promoted.
applicant is been promoted.
What was that name? Anna?
Grace
Broder.
Broder is now
Grace?
connected.
Okay. You
And
see
then-
anyone else out in the audience?
Public testimony from Richard Hernandez. Mr. Hernandez, I have sent, is currently accepting the promotion and he is connected.
Great. Trying to see him yet. Sir Hernandez, I think I'll recognize your face. Yes, I do. Sir, will you please raise your right, both people raise your right hand to be sworn in? Do you solemnly swear or affirm to tell the truth and nothing but the truth during this hearing today?
I do. do.
State your name, please, Mr. Hernandez.
Richard Hernandez.
Thank you.
Grace Broder. I do.
Thank you. Is it Boder, Grace? Is it which?
Broder.
Okay, thank you. There are some administrative exhibits found on page 3 of your staff report labeled 1 to 9. We need those to hear your case today. Can we admit those with your approval?
Yes, please.
Okay, thank you. Those are approved. Part of that is a presentation by city staff, Mr. Clements, and he'll present your case. Go ahead.
Thank you, Mr. Chair. So before us, we have docket item number 14, case number 9, 2023. Located at 2131 Bellevue Avenue, zoning district R6, applicant is seeking approval of a variance to the side yard setback requirements to allow for completed and enclosed porch addition to receive as-built permits. So here's the location of the subject site. It's in the West Side neighborhood. More specifically, it's on Bellevue Avenue, just north of West 23rd Street. So here is a picture of the completed or mostly completed structure. Encroachments place are on the side of the property between, it should be on the left of your screens. The large concrete buttress or whatever that is, whatever the term for that is. I'm not familiar with the contemporary names for that architectural style, but the area between the side of the porch essentially and the side property line is what's causing the encroachment. So there are 2 variance requests being sought. One is for 1 inch for the existing exterior wall of the home. Other is for 1.26 feet porch column. Is the word I was looking for. So substantial change to the character of the neighborhood is not anticipated for either variance. The difficulty could not be obviated by a feasible method other than a variance, other than placing the existing structures. With that, I'll conclude my presentation.
Thank you, Mr. Clements. Ms. Grace, why should we approve your project today?
Sure. So I'm here speaking on behalf of the owner, Roger Espinoza. For a little bit of context and history on the project, the owner did buy the property. It had a deteriorating facade, and as part of the improvements, the owner did undertake both interior and exterior renovation without permit. The project was placed on hold, and it's as-built condition, as you saw in the picture, and they attained professional services of architects and structural engineers. And we've been permitting the project through the city. The city has approved all of our plans reviews for the residential plans review. For zoning review, the variances that we're requesting have been flagged. And so that's why we're here today. The structure, the foundation of both the side and the front of the project have not changed from the existing structure. So the concrete foundation and the exterior stud wall remain in the same location. Additional layers of cladding have been added both to what would be the north side where the setback encroachment is being requested, as well as that trace or buttress that Jared was describing has been added. The porch before was a 3-sided open porch. This addition to the front encroaches on the front setback and is not open on 3 sides. And thus the zoning review has asked us to request a variance to allow this encroachment on the front setback.
Okay. So the footprint of the house is really the same footprint because you said you used the existing foundations from the old home?
The front and the side setbacks are the same. They did add an addition onto the rear. That addition is in conformance with all zoning code and has passed plans review as well as zoning review.
Okay.
And a small note of clarification, it doesn't, probably won't matter either way, but the original request that they did submit included a front setback variance. Since their original plan review for this, we passed the infill residential context area ordinance. If you all are familiar with that, if you're not, it's a ordinance that essentially, rather than doing a kind of strict setback, if you're within a certain, the infill area of the city, you can instead use the contextual street facade that you're on and kind of take the averages of those. So the front setback that was originally on those plans is not required anymore after review. So just those side setbacks, as mentioned in the staff report and in the PowerPoint, remain. The front setback is conforming.
Okay. Thank you. Board members, any questions? And then we'll hear from of Ms. Grace, and then we'll hear from Mr. Hernandez.
Yes, I do have a question. How did you determine that with the added siding that it's 1 inch closer to the property line than it ought to be?
That's a good question. So we did not have a survey for this project, but we did use existing walls on the south side of the property as the property line, and field measured from there when we submitted plans to the city. We then also, from those drawings, showed a percentage for our setbacks initially in our submission of permit. And it was a fractional inch within that percentage that we showed, and the city requested that we add an inch to be on the rounding up side of that percentage. So that's what has triggered this 1 inch requirement.
Okay.
Anyone else? Mr. Hernandez, could I hear from you, please?
Yes, I'm still not sure what they're after. Do we have drawings or pictures of what they're trying to do in the back?
Well, sir, we don't, but it's in compliance with the existing code. So whatever they're doing back there, they're okay. If Miss Grace wants to share those with us, she can.
Yeah, I can share elevations, but we have permitted those through the city. I don't know that that would be needed to be shared.
Well, I mean, with all the zoning review problems they had, is just plentiful. And then here they are asking for another variance, which is getting a little out of hand. And then they still got the backyard that's unfinished. How many variances are we going to grant? And I can't see the back. I mean, I don't see a plan for the back.
Well, Mr. Hernandez, not that it matters, but Ms. Grace has presented those to city staff and planners, and those are all within the setback. and approvals, the ones in the side and are the ones that are in question today, sir. And it's 1 inch on one side and 1.5 feet on the other, I believe. No,
1.26.
Yeah, one inch on one, thank you. And 1.26, 1.25 feet on the other, which
As a point of clarification, the additional 1.26 is from that front view that you're seeing. It's the trace or the buttress that we're calling that front porch that traces that gable roof line. So the clapboard facade beyond is 1 inch, and then the protrusion of the that trace is the 1 odd foot protrusion, which is being requested on the same north side setback.
Now, the front porch already sticks out past the other properties. So that's why I'm questioning this. Even if I can't see it, I should be able to.
I'm sorry, Mr. Hernandez, what'd you want to see again, sir? I'm
Sorry,
sorry.
you won't show me the pictures of what they're looking at or drawing. I'd like to see that. But even all the requests have been granted. The front is already sticking up in the front past the other yards already.
Now we're going to share a screen that we're looking at here.
Yeah, look at that front porch. It sticks out way past the other homes already. So I'm saying they keep granting all these variances. It doesn't match the neighborhood. Doesn't match the other houses.
I think as Mr. Clements described with the new infill ordinance for KCMO, this does meet the ordinance requirements with that percentage from kind of the setback from the road now.
So the only variance in question is the 1 inch side yard, correct?
And 1.26 on the other side, sir.
So if you can see my screen, Mr. Stiller, where my mouse is now is the 1 inch variance. And then this enclosure, though it looks similar right here, as if you look to the top of the structure, you can see that it actually protrudes a bit more. So the second variance is basically to allow for that concrete buttress, as Ms. Broder called it. They're both on the north side. The rear yard, they don't need a variance for. It's whatever's going on in the rear of the property is permitted. They also do not need a variance for the front yard encroachment.
So just that one facade, 2 variances, one for 1 inch and one for 1 inch 3 inches. Or 1 foot and 3 inches.
1 foot, 1.25 feet, basically.
1 foot 3 inch.
Yeah.
And 1 inch.
Like 13 inches or something, 14. And it's all on the same side, Mr. Stiller, if you see.
Right. Front of the house is in compliance.
Yes.
Okay.
Nice.
Okay. Mr. Hernandez, I'd like to point out that it's a contemporary design and a lot of things on the west side are not, and I understand your concern, but people like to do different things to their homes. So we're not the architectural committee. We're just the people who grant an inch or 2 or sometimes 14 inches or more for them to build the house they like. So, but I do understand your concern, Mr. Hernandez. You've spoken with us before here.
I would offer a motion.
Oh, yes, thank you, Ms.
Is
Mixer.
there other questions? In case number 9, I move the applicant's request be granted in accordance with site plan and staff report.
I have a motion. Do I have a second?
Second.
Second.
Thank you, Mr. Gorns. Anna?
Lawrence.
Aye.
Brand.
Aye.
Extorf.
Aye.
Stiller.
Aye.
Ebbets.
Aye. Your project is approved, sir, or Grace, I'm sorry. Please proceed with it as directed. Thank you.
Thank you. Thank you for your time.
Thank you for your testimony, Mr. Hernandez. Thank you. Our last case, it appears, is docket 16, case number 2 with an address of 11511 Blue Ridge Boulevard. Mr. Banday, I know you've spoken with us before. Can you turn on your camera and microphone?
So from what I could tell, Mr. Banday was given a recommendation of denial by the
I see
CPC
that.
last week.
Yeah.
And it appears he has not shown up to this hearing. We did try to call him. We might continue this a month if the board wants to do so. If you want to give him a chance to attend or whatever the board wishes.
I think it would make sense to give him a chance to attend if he so chooses. And if that during that time he chooses to dismiss the case or whatever that may be, we can.
Sure.
So do I have a motion to continue docket or case number 2 to the March 14 docket?
So moved.
Second from somebody?
Second.
Thank you, Ms. Moran. Anna, please call the roll.
Lawrence. Moran.
Aye.
Stiller.
Aye.
Extorf.
Aye.
Abbots.
Aye. And with that, our Valentine's Day special BZA hearing has completed. Everyone take their spouses out for dinner tonight.
Fine.
In this case, or this board is adjourned.
I thought Meg, you did the electronic gavel drop there.
Just pound the table.